For those that don't know me, my name is Jake Evans. I'm chairman of the commission. I appreciate all you guys coming out today. We've got a pretty full agenda, so we'll try to go through it as efficiently as we possibly can. As I just mentioned off the record and now on the record, our court reporter is running a little late, so we will adjust the agenda. And to that order, I will make a motion, commissioners, that we modify the agenda, and after agenda item 2, review and approval of meeting minutes, we hear what is now marked as item 6 on the agenda, administrative dismissals, and then 7, rules for consideration, and then 8, report of the executive secretary, and then 9, report of the attorney general, and then 10, scheduling of dates for the 2020 quarterly meetings. We'll still save the public comment for last. If I could get a second for that motion.
Second.
Okay, we've got a motion and a second. Do we have any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed? Okay, so the motion carries. So we've modified the agenda to that effect. And before we get to the revised items, we will go with review and approval of the meeting minutes for the regular meeting at September 26, 2019. I hope all the commissioners had an opportunity to review those. And is that Secretary Amati?
Just one point, Mr. Chairman. There was a typo. I see Mr. Clark.
I don't know if you can classify that as a typo. Go ahead.
So in the meeting minutes, it lists former Commissioner Alan Yee as present instead of Commissioner Thompson. So I think someone needs to make an oral motion to amend that.
Okay, and who called that?
Mr. Watts.
Mr. Watts, okay.
Did you need to ask a question?
Well, I'm just glad that commissioners are reading the meeting minutes, so that's reassuring. I appreciate that. Okay, I will make a motion to adjust the minutes to reflect that change for Commissioner Thompson to replace Commissioner Yee. And are there any other modifications that we have? Okay, hearing none. I'll restate the motion. Motion to approve the meeting minutes for the regular meeting September 26, 2019 with the modification that Commissioner Alan Yee is replaced with Commissioner Rick Thompson. If I could get a second.
Second.
All right, we got a motion and a second. Do we have any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed? All right, the motion carries. So next we'll go to what is now going to be agenda item 3, administrative dismissals, and then who on behalf of the commission staff will be handling that.
I have 3 administrative dismissals.
Okay. And if you could state your name for the record, please.
It is Jim Cusack, Joseph Cusack.
Okay.
Senior staff attorney, Commissioner.
All right, Mr. Cusack, go ahead.
All right, the first administrative dismissal in order of what is on the agenda is Thomas Randy Toms. Mr. Toms is the current mayor in Houston County in Warner Robins. This was a third-party complaint that was filed by the Houston County branch of the NAACP. It was sent to a couple of different state agencies, basically the agencies that oversee elections or have anything to do with elections. So it went to a couple different agencies, one of the agencies being the Campaign Finance Commission. The complaint is basically stated in 3 parts. There was 3 allegations that were made. The first allegation was the only one that deals with the Campaign Finance Act, and it was stated that the respondent, Mr. Toms, received questionable campaign contributions. The second allegation is the respondent participated in hiring made improper hiring practices for the election supervisor and assisting personnel to the election supervisor in Houston County. And the third allegation was that he improperly used the Houston County City Hall for early voting. The second and third allegations can be dismissed right away by the commission because we don't have jurisdiction over those. We have no jurisdiction. They don't deal with the Campaign Finance Act or anything of the sort. So those 2 were dismissed right away. The first allegation in which he received questionable campaign contributions was again in about 3 parts. Basically, it alleged that he took $2,500 from 3 employees of the ICB Construction Company, which is under the legal limit for each person. Those 3 people were not family members. They were not in concert with each other. They were just employees, and they gave this money. And part of the allegation was that they received construction work because they had donated to his campaign. There was no evidence to back that up. So basically, they had made lawful contributions, and they thought that that was unfair. Turns out that's in the law. They're 3 separate people, not family members, not anything like that, and they did not make them in concert with their company. They just worked there. So that was okay.
And is the complainant here today? Do we know?
I do not believe so.
Okay.
There was a second allegation that suggested that people who had given money to his campaign, to Mr. Tom's campaign, that they received favorable terms of business with the city. There was no evidence to support that, so the commission dismissed that complaint, or that portion of the complaint, and there was no documentation for that as well. There was a third portion of the first portion that was alleged that basically there were, he said it was unsubstantiated, but that again, there was some business that was given to people who had donated. And there was no, he even admits in the complaint, this is pure conjecture of things I've heard from another person who heard from another person. So that was why we dismissed the complaint, because there was no evidence to actually show any of this occurred.
Okay. And do the commissioners have any questions? Okay. Hearing none, I'll make the motion that we, pursuant to your proposal, dismiss the complaint. Is that Secretary Monty?
Yes, Mr. Chairman, technically with administrative dismissals, you don't have to make a motion to accept. I'd administratively dismissed. You would only make a motion if you reopen
Okay.
the prosecution.
So no further actions required for the commission. Okay.
The second one is in the matter of Friends of Splost Committee, and that was case number 2011-0025. This was a third-party complaint filed by David Massey that a ballot committee that was Friends of Splost in Butts County made expenditures of over $500 without reporting these expenditures to the election board. This complaint was filed about 3 years and 8 months after this actually occurred. There's a 3-year limit of statute of limitations for a ballot committee. So this complaint by Mr. Massey was filed after the statute of limitations, so that's why it's being administratively dismissed by the commission. There is also an issue of staleness, given that it is 2019 and this occurred in 2011. It would be nearly impossible to actually get any evidence regarding this ballot committee in the form of bank records or campaign materials. So that's also part of the reason this is being administratively dismissed.
All right. Any comments, questions from the commissioners? Okay.
The third one is in the matter of Jefferson Clark. That is 2015-0065. This one, Mr. Clark already has a pending case at the Attorney General's office for some other campaign finance violations that he has, or that has been found there was probable grounds to proceed by the commission. He submitted this allegation that was made was that he did not file CCDRs. He actually filed, since he was a local candidate, filed an affidavit stating he would not take more than $2,500. He filed an affidavit with the commission saying he did not do that. There was no evidence to the contrary that he actually expended or received contributions of over $2,500, and that was the crux of this allegation. So that's why it's being administratively dismissed. There was no evidence that an actual violation of the act had occurred.
Okay. Commissioners, comments, questions? All right. No further action on our part? Is that all the...
That's all I have at this time. I believe Ms. Browder may have two.
Okay. Great. All right, Ms. Browder, whenever you're ready, we're ready.
Good morning. The first administrative dismissal I have is for Shirley Yvette Bland. It's case number 2017-220 PC. and this case resulted from an audit that the commission performed. The audit showed that Ms. Bland had some late fees. A late fee notice was issued to Ms. Bland. And, I'm sorry, excuse me, the late fee notice was issued to Ms. Bland showing that she had not received a personal financial disclosure that was due for July 1st, 2017. Ms. Bland owed $125 for the unfiled report. After receiving service of that, Ms. Bland paid the late fees and filed the report within 1 day. And so there are no outstanding reports or fees for Ms. Bland, and because of that, we are recommending that this case be administratively dismissed.
Okay, good. And I think it was $125, not $1,200.
I say 1200.
Yeah,
Yes,
that's
it is
fine. That is
125.
Thank you for that. And any comments, questions, Commissioners? Commissioner Thompson?
And this might be for the executive secretary. Why did the commission start a case in the first place on this if it was just a late fee?
It was a random audit.
Oh, so the random audits get assigned a case number?
Yes.
Okay.
Okay. Thank you, Commissioner Thompson. Thank you, Ms. Bauer, for that one. No further action on our behalf is required, so whenever you're ready for the next one.
Okay, and the second and my last case is for Dwayne Harris, and that's case number 2019-14. And Mr. Harris's case is a result of a third-party complaint that alleged unregistered lobbying. The complaint alleged that Mr. Harris engaged in lobbying of Representative Debbie Buckner related to a Department of Natural Resources bill. The complainant stated that he observed Mr. Harris lobbying at a committee meeting, and he also said that Mr. Harris was working on behalf of the Chamber of Commerce, and the complainant didn't have any proof of any compensation for Mr. Harris from the Chamber of Commerce, but he suggested that as payment, Mr. Harris received placement of an advertisement for his business on the Chamber's website, and that also the Chamber paid for a trip to Atlanta for Mr. Harris. Mr. Harris, in his response, stated that his business that no longer is in operation was placed, the name of the business was placed on the Chamber website, but that's just a general practice according to Mr. Harris for all members, business members of the Chamber, and that he did not receive compensation for his trip. The complainant also alluded to Mr. Harris's extensive knowledge of the subject matter being discussed during the Natural Resources Committee meeting, and Mr. Harris explained that he had worked multiple decades for the state of Georgia as a director for the Department of Natural Resources, and that was the reason why he had substantial knowledge, and that is also why he decided to speak with the representative, but that he at no point spoke on behalf of any entity and was there expressing his personal feelings. That's really the extent of the proof that the complainant provided, and so for that reason, we're asking that this case be dismissed because there was no substantive proof of compensation or actual lobbying on behalf of any entity by Mr. Harris.
Okay. And for Ms. Bland, is the complainant here today? All right. For the Harris matter, is the complainant here today? Okay. Any comments or questions? All right. Hearing none, no actions required on our behalf. We thank you, Ms. Brower, for presenting those. And we will move to the rules for consideration. And Secretary Mahdi, are you the one that wants to talk through the two considerations we have?
Mr. Lane will pick up where he left off.
Okay.
Good morning, Commissioners. You're considering today two different rules, an amendment to Rule 189-2-.01, as well as the adoption of a new rule, which is 189-2-.11. The amended rule is seeking to amend definitions that will assist in the new rule, which is point 11, and point 11 is a rule of procedure for the award of attorney's fees. The commission has considered these proposed rules twice before. At your last meeting, there were comments submitted by Mr. Doug Chalmers, and at that time, the commission had two changes. One change, which of course commission staff agreed with, was the changing of may to shall within Rule Point 11. So instead of saying the commission may assess reasonable attorney's fees, it says the commission shall assess reasonable attorney's fees if the commission finds that a case is frivolous and lacks legal merit. The additional change that the commission wanted to see after its last hearing was contained within the definitions, and it was Rule 189-2-.01, subsection 16 regarding legal merit, in which Commissioner Barnum requested that is advanced factually by the complainant in good faith be included, and that those two changes have been made. The rules were posted within the 30-day period for public consideration. No additional comments have been received by the commission as of the deadline, and I checked a few minutes ago, we still haven't received any rule comments. So it's within the commission's purview to either accept, modify, or reject.
Okay. Commissioners, any comments? Commissioner Watts?
Looks like the third time's a charm, Mr. Lane.
I hope so.
But my only comment is I think it would be helpful if we could put these on the website in a very easily accessible form, just because I know there's been so much uncertainty about attorney's fees, whether you can pursue it, how you can pursue it. So if this change is adopted, I would make the request that we do that. Does anyone want to make a motion?
I'll move that we adopt the new rules.
Okay, Commissioner Watts has moved that we adopt the roll. A second? All right, we got a motion and a second. Any discussion? Hearing none, I will call the question. All in favor of adopting the new rule 189-2-.11? All in favor say aye. Aye. All opposed? Hearing none, the motion carries. Thank you, Mr. Lane. Are you presenting?
One more, you've got to adopt the amended rule, which is .02 as well.
Okay. Well, I will make the motion to adopt the amended rule 1.89-2-.01, if I can get a second.
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed? All right, both of these pass. I'm excited that we have some clarification and certainty on attorney's fees before the commission. Thank you, commission staff, for preparing those rules and being patient with the commissioners as they modified it and finalized it. Next, we've got the report of the executive secretary. Before we do that, any update on the court reporter?
She's
Yes,
here.
sir.
So
Okay, she's here. Does she need to set up?
yeah, she can probably go first.
Yeah, I'd go ahead and set up, ma'am, if you could. Thank you for coming. I know that Atlanta traffic is a lot, so you've got, take your time. All right, Secretary Motti, go ahead.
Thank you, Mr. Chairman. There are 4 items I want to talk about today. As the commission staff, and I think the public will recall, in April, upon coming on board, I ordered that among other things, the 2017 Atlanta mayoral audit, which had been ordered by my predecessor and then shut down at one point, be reopened and be completed. In the interim, since late April, we have spent a lot of time and resources in that case, particularly, and I want to credit Mr. Lane over the last 3 months, working through quite literally tens of thousands of reams of paper, which is inherently a problem with the software system we have now relative to the local is generally by paper. But as a result, late last week we concluded the last of several audits. As a result of that investigation, having reviewed campaign disclosure reports, we filed additional allegations in 2 separate cases against candidates for mayor in 2017, alleging that they accepted a fairly significant amount of money in improper campaign contributions. We have issued subpoenas into bank records for both of those campaigns. I'm not going to talk substantively about those cases, given that they're active investigations and ongoing, but I did want to update the commission that has been a priority of the staff in 2019, and we have made significant progress there. That does lead me into, however, last meeting we talked about consent orders where money was past due and how we put considerable time and effort into actually collecting those monies, which were as long as 3 or 4 years overdue for payment. And I believe we collected in the range of $30,000 in money that was owed but not paid. To that same end, and I'll talk about our city and county audits in a moment, but our legislative liaison, Mr. Morris, has been working with City Hall in Atlanta about a number of past candidates and officials who owe a significant amount of money in late fines. We have whittled that down to 63 officials or former candidates who owe money that is outstanding. At this point, those 63 officials owe, if my math is correct, which is never a guarantee, but somewhere in the range of $29,500 in money due to the commission. We continue to work with them, but we are reaching the point where we will be referring this not to Mr. Fuller, but to the Attorney General's office for a Special Assistant AG to file enforcement actions in Fulton County and ensure that those monies owed are collected. Another priority when I took over to try and bring our standards back to par was a targeted local audit of cities and counties. Members of my staff, at somewhat random, picked a collection of cities and counties that were both politically and geographically diverse. So we picked cities and counties that were both of the Republican and Democratic bent, and both rural and urban and suburban. We are in the process of auditing at a preliminary level a number of cities and counties. I am not professing that this will be done overnight, but this is something we're working towards. Those locations include the city of College Park, Cobb County, a city in Bartow County spelled Euharlee, which I have since learned is pronounced Euharlee. It also includes Effingham County, the city of Douglasville, Carroll County, Bacon-Bibb, the city of Griffin, Chatham County, and Gwinnett County. The next item on my report deals with archives. We have spent the last several months working with the State Archives and Board of Regents to actually create an archive policy that complies with state law, and I believe we've finally gotten approval and that has gone into effect. So there is uniformity with how we will keep all of our records moving forward. And finally, I've talked about technology a lot. One update on one of the projects we had. We have implemented a new case management system internally in the office. Prior, the case management system consisted of Microsoft Excel and sticky notes. So this new system creates a more streamlined approach with tech. It also has an online payment portal for people who need to pay money to sort of bag into and pay. So I am optimistic that this will make us more efficient in the office. With that, Mr. Chairman, I will yield back.
All right, thank you. Although I live off of Excel and sticky notes, so I don't know if that's a good or bad thing. I'm just kidding. Thank you for you and the staff's efforts in making all those developments. I know it's a lot of hard work, and the commissioners appreciate your hard work in making that happen. All right, Madam Court Reporter, are we up and running? Are we close to it? We're all right. So what we'll do, Christian, okay, I'm going to make a quick motion to move what's currently agenda item 9 and 10, the report of the Attorney General and scheduling of dates for the 2020 quarterly meetings respectively, back to the end of the agenda. If I can get a second for that. Second. All right. Any discussion? Hearing none, I call the question. All in favor say aye. Aye. All right. Thank you guys, and thank everyone for your patience. All right, so we are up to motion to quash, and we've got 2 matters that are up in the matter of Neil Warren and in the matter of the new Georgia Project and new Georgia Project Action Fund. So who is here, Mr. Chalmers? How long do you expect to take?
Mr. Chairman, probably 10 minutes.
Okay. And who on behalf of the staff? And how long?
I anticipate about a second.
Okay. Well, go ahead. Mr. Lane, whenever you're ready.
Mr. Chalmers is the move in, so I believe you should get
Okay.
this.
They can use the passwords.
Sorry, spell your last name for me.
Good morning, Commissioners. My name is Doug Chalmers. I'm here representing Sheriff Neil Warren and the committee to re-elect Sheriff Neil Warren. This is a hearing on a motion to quash a subpoena that we have filed in this case. Actually, a number of subpoenas were filed in this case by the commission.
Sorry, Mr. Chalmers, but before we start, last night we received a letter brief from you requesting Mr. Thompson's recusal, Commissioner Thompson's recusal, and before we jumped in, I wanted to address that if you wanted to speak on that, and then if Mr. Lane had any comment, and then I would let Commissioner Thompson speak as well.
Yes, sir. That actually was the first thing on our agenda. I'm just going to find a spot for this, sorry. As the commission is aware, we've dealt with this before. The Attorney General has issued an opinion that basically states it's not up to the commission to make a determination, it's up to the commissioner himself to make a determination about whether to recuse. Our recusal motion is based on the fact that before the case commenced against our client, and I think it was before, I'm sorry, it was before Mr. Thompson became a commissioner. The case may have already commenced. Mr. Thompson, as part of his professional practice before joining the commission, was a source for the media on many cases, as I have been from time to time. But in this particular case, he made a number of comments to the AJC in an article that came out in July that were hostile to our client, that basically said that a number of issues needed to be investigated, talked about the petty cash question, questioned some of the expenditures that were made. And the motion to recuse is based on that premise. We respectfully submit that we don't think there are many judges, if any judges in the state, that would vote on a case on issues after having already publicly commented to the media on them. And one of the reasons for that is that having already made certain comments about a case, there's pressure to back those up once you're on the commission in a position to actually vote after having heard all the evidence and the legal records. So the motion is directed to Commissioner Thompson, and we respectfully request that in light of his public comments about this case before joining the commission, that he recuse himself from the case.
Mr. Lane, do you have any comment?
No, Mr. Chairman, the staff takes no position on the motion.
Okay. And I'll make a quick statement. This is the same statement that I've made requesting any recusal of a commissioner, and that is that the commission adopted a policy about 2 years ago, and the policy effectively said that the chairman could move to recuse or require the recusal of a commissioner. That rule is actually directly inconsistent with an attorney general opinion, which says that it's up to the commissioner's discretion on whether they should recuse. And to that effect, I will defer to Commissioner Thompson if he feels that he needs to recuse or that he can't act impartially. So Commissioner Thompson.
Thank you, and I do appreciate Mr. Chalmers being so diligent with his client, but I'm very comfortable and confident that I can be impartial. I will not recuse myself.
Mr. Chairman, we simply ask that a copy of the motion to recuse be included in the case file.
Sure. Go ahead, Mr. Chalmers.
Thank you, Mr. Chairman. As I mentioned before, this is a motion to quash, and the issues we're going to be discussing today are almost entirely legal, and they concern the Commission's processes for conducting investigations. They involve interpretations of the statute and what must or must not occur before the Commission staff may conduct an investigation on its own cognizance and issue subpoenas. Before we get into that, I think that the PowerPoint is not functioning up on the screen. Is there a way to get this up there?
Needs to be.
No, you're fine.
Mr. Chairman, may I approach?
Sure.
Thank you.
For the record, I appreciate Mr. Lane helping me with this. This is not part of the job description.
But he did say he'd share his fees with you.
Was it working earlier?
It was.
All right, something happened. Perfect. Thanks, sir. Thank you, Mr. Lane. Appreciate the help.
No problem.
Before we get into the merits of the legal arguments, I want to make sure that we're clear on what the standard is for principles of interpretation that are supposed to be applied. In a response to our motion to quash that was filed with the commission and provided to us just late yesterday afternoon, the commission staff emphasized case law, which states that an agency or court should give deference to the agency's interpretation of a statute. I want to clarify that the two cases that were cited, and I apologize, I haven't had time to put together a written motion or response since we just got this yesterday afternoon, but I'm happy to do that. Neither of those cases that were cited involved quasi-criminal actions or they involved the Ethics Commission. First of those cases was Center for a Sustainable Coast, and that involved the Coastal Marshlands Protection Committee and the question of whether a Coastland Protection Act extended to residential activities in upland areas. Tibbles involved a calculation of retirement benefits under the teacher's retirement system. In those kinds of cases, which are not quasi-criminal and don't involve the Campaign Finance Act, the courts have said that the agency's interpretation of a statute is entitled to deference. That does not apply to the Campaign Finance Act. In State Ethics Commission versus Moore, which is in the physical packets, which I've also provided to you and is up on your screen, the Court of Appeals in an en banc decision made it very clear that the election law is a derogation of the common law and is a quasi-criminal statute that must be strictly construed. As such, when we're talking about this issue today, any inferences or ambiguities in the law must be resolved in favor of the defendant, and I respectfully submit that the argument that the agency's interpretation would be entitled to deference misapplies the case law. So let's talk a little about what the Commission's power is, and move to the second document in your packet there. The Commission's investigative power very basically differs depending on whether or not a case initiates with a third-party complaint or by the Commission on its own cognizance. The Commission's powers on this are set out in 21.5, subsection 6, B9, and B10, which are up on the screen and in your packet as well. I'm not going to read it. We can talk about the specifics if we need to after Mr. Lane has made his argument. But the bottom line is, at the very end of it, it says that nothing in here, nothing in this statute in B9, shall encumber the right of the Commission to initiate on probable cause an investigation on its own cognizance as it is necessary to fulfill its obligations under that chapter, or under this chapter. Subsection 10A, which is a little further down, says exactly the same thing at the end. In addition, the next document in your packet is 21.5.7, which is limitations on authority, and this is talking about the certain requirements that apply when investigating written complaints from third parties. At the very end, it again says that nothing in this provision shall encumber the right of the Commission to initiate on probable cause an investigation and as it deems necessary. So those provisions have been in the law for a very long time. And a packet, item number 4 in your packet, is that, well, as far as we are able to determine an accurate summary, an actual copy of the law that existed in 1982, which will be the reason why that date is relevant will be explained in just a second. If you will turn to the end of that document, subsection, sorry, I have a hard time navigating this computer. Subsection 40-3809, as it exists at the time, sets out the powers of the Ethics Commission. Subsection E9 contains, E9 and 10 contain the same basic language that exists now in 2156B9 and B10. Make investigations subject to the limits in this code section with respect to reports and statements filed under the chapter, with respect to any alleged failure to file statements or report, or you can investigate a verified written complaint from a third party. It contains the exact same language at the end talking about initiating a case on its own cognizance. The exact same language that is in 2157 now also appears later in this older version of the statute at 40-3810, which is on your screen and is toward the back. We've highlighted the relevant portion, again referencing a finding of referencing probable cause to initiate an investigation. So what does that mean? Well, in 1984, the Supreme Court told us. In 1984, and this is the next document in your packet, the Supreme Court decided the case of Caldwell versus Bateman. And this is a case where the commission was in the early stages of its involvement with candidates and elected officials in enforcing the act. You'll notice that this is 2 years after the copy of the statute that I just provided to you. So those provisions were in place at the time that Caldwell was decided. And the allegations that were made by the defendant in that case was that the commission had not engaged in proper procedures. It had conducted investigations, issued statements to the media, issued subpoenas, held hearings, and not followed any of the proper procedures in the act. As part of a discussion of the due process requirements and arguments that were raised by the defendant, the Supreme Court said in two cases, and that's highlighted for you in the opinion, that there must be a finding of probable cause. The first one is right there. When it talks about the facts of the case, it says the investigation and other activities were undertaken without the support of a written verified complaint and without a finding of probable cause. Further down in the opinion, right here, highlighted for you, it says unequivocally, the Act, meaning the Campaign Finance Act, provides the commission shall not initiate any investigation unless, number one, based on a written verified complaint, by which they mean a complaint from a third party received by the commission, or two, based on a finding of probable cause by the commission when the commission initiates its own investigation. Neither requirement was met in this case. So the Supreme Court made it very clear in 1984 that when the commission itself initiated the investigation, it had to make a finding of probable cause. Note that this doesn't say a finding of probable cause by the commission staff. It says a finding of probable cause by the commission. And there are reasons for that, which we'll talk about in just a second. The next item in your packet is the minutes, and Mr. Thompson is very familiar with this because he was the executive secretary, or interim executive secretary at the time a number of these cases were resolved and signed a number of these minutes. They're provided to you in abbreviated form in your packet. Only the relevant pages are highlighted there. But as you can see from those minutes, on a regular basis for the quarter century after Caldwell was decided, the commission staff would come to the commission members, say that having reviewed disclosure reports and obtained information through the review of those reports, we've concluded that there is a possible violation here. We request that the commission vote to make a finding of probable cause to investigate on the following grounds, the possible following violations. The commission members would then cast a vote on a motion to decide whether to move forward. And I'm not going to go through all those minutes in detail. I've provided to them by way of example. And I want to show you, with your permission, Mr. Chairman, one video of a commission hearing that took place in 2006 in which this commission, the prior commission, did exactly that. This is about 3 minutes long. Apologize, it's not connected to the sound, so hopefully it will go to the microphone. Just by way of reference, on the far left is Teddy Lee. Teddy Lee was then the executive secretary of the Ethics Commission. The gentleman next to him, I don't believe is a member of the commission. I think he was either with the Attorney General staff or with the commission. The next four gentlemen to the right were members of the commission.
We do have three of those, Mr. Chairman. They're in your package at the time. If I could just, I guess we'll take them off in alphabetical order. We've got IBEW, and that's one where during a routine audit of various campaign contribution disclosure reports, it was discovered that IBEW, code IBEW, Local 613 PAC, had made more than $5,000 in contributions to candidates in the years 2001, 2002, and 2003, but they failed to register and file reports as required by 21-5-34E. And they also, it's also possible, although we don't have the commission determine this at this point, but we will look into it. I think there's probable cause to open an investigation on this point. It's also possible that based on the identity and the relationship between IBEW, COPE, and IBEW Local 613 PAC, that they may have violated contribution limits if those are affiliated committees. But at any rate, we would simply ask the commission to find that there's probable cause to open an investigation and determine whether there are reasonable grounds to believe the Ethics and Government Act has been violated in all of those points. You can see from the attachment that we're talking about a total of over $76,000 in contributions over the periods covered. These are contributions, IBEW code and IBEW Local 613 PAC fund did not register or disclose. We picked them up. We've begun after we have had some cases where we found these non-candidate campaign committees not disclosing. We've begun to sort of go through candidate disclosures and see if there are more, and that's how that this one was picked up. So one would think so. Usually unions are very knowledgeable about these things, but so are the corporations usually very knowledgeable. Okay.
So that is how the commission did it. Yes, sir.
When was this from?
That is in one of the minutes that's in your meeting. That is the hearing of February 23rd, 2006.
Mr. Chairman, for clarification, the gentleman sat to the right of Mr. Lee was Commissioner David Moskowitz, so they were all commissioners.
Thank you. Apologize. My mistake. Thank you, sir. So that's how the commission is supposed to do it. And that's how they did it for 25 years. At some point, it appears likely, although the video of this relevant meeting is not available anymore, it appears likely that Mr. Ritter was the Attorney General's office employee who at some point advised the commission that it no longer needed to cast those votes. In recent years, those votes have no longer occurred. And what does the commission staff do these days? Well, What they commonly do is they will investigate their reports, they will look at the report disclosure reports, they will issue subpoenas, they will issue a notice of inspection, and they will file a complaint on behalf of the staff. And because the media is always interested in Ethics Commission's cases, and because the position of the commission is that the complaints are subject to Open Records Act, those complaints immediately get in the hands of the media. And so without this commission having ever made a finding of probable cause to initiate an investigation, a public official is getting excoriated in the news and getting subjected to numerous subpoenas, even if those subpoenas mistake the law, or even if they are overbroad, or even if there's been no finding whatsoever by the commission to conduct an investigation. One of the things that I think is important to note is oftentimes, as is the case here, the complaint itself asks the commission to make a finding of probable cause. If you look at the complaint in the Neil Warren case, which is before you, if you go back to the last page of the complaint in the prayer for relief, sorry, I'm scrolling down. You have the first page and the second page of the complaint in your packet. This is prayer for relief in this complaint. Wherefore the commission staff prays as follows: a process issue and respondent be served a copy of this complaint for a finding of probable cause. What in effect has happened is that the commission staff now files a complaint, conducts an investigation without any oversight from the commission or finding of probable cause, then asks the commission for a finding of probable cause at the preliminary hearing. There are lots of minutes of commission meetings in recent years where the commission has voted to find probable cause at the preliminary hearing because it's a probable cause case, meaning one that started with the commission staff. Although the standard you're supposed to meet at the preliminary hearing is, are there reasonable grounds to believe there's been a violation, at which point it goes to the APA. The only time the Act ever mentions probable cause is in the standard that authorizes the initiation of an investigation. We respectfully submit that the current practice is inconsistent with the Act and is inconsistent with the Act as it was interpreted by the Supreme Court in Caldwell. If you would like, Mr. Chairman, I can address some of Mr. Lane's arguments in the response that were filed yesterday, or wait until after he's had an opportunity to speak
Let's wait. And Commissioner Watts, you...
In the same packet, and I apologize, I've got a cold, so it's hard to hear me. But in the same packet, you had highlighted the minutes where there were requests for finding the probable cause. On page 7, it's also highlighted, and it's at the very top, and it says that after a discussion with the Attorney General's office, it was determined that under the Ethics in Government Act, the commission staff may have and investigate a probable cause case without an official vote by the commission. What do you make of that?
Well, unfortunately, and this is not the fault of the current commission staff at all, but the video of that meeting no longer exists. It's on the commission's website. The minutes of the meeting don't identify who the Attorney General's off staff or was who advised that. My assumption is, based on who was representing the attorney, who was working in the Attorney General's office to represent the commission at the time, is that it was Mr. Ritter. We've submitted an Open Records Act request to the commission asking previously for any information about that meeting, about that recommendation that's not privileged. And my understanding from Mr. Lane is nothing exists going back to that time frame. But that's the point at which the commission stopped doing this. And then as you all are aware, for a number of years, there was some staff issues and lawsuits in the commission, and so it tended to, although it was functioning fairly effectively under Mr. Thompson's leadership, when he left, there was a lot of problems. And the commission didn't do much. This issue has come up recently because the commission is now aggressively issuing subpoenas. And I think that there needs to be some historical tie back into what is the commission's authority, what was it interpreted to be by the Supreme Court, and we need to get back to that.
So one follow-up. Is this the same argument, if I recall correctly, generally at least, that you were making on behalf of Mr. Oxendine?
It is correctly, that's exactly right. The Caldwell case we did not have in front of you, that's my fault. Neither the Attorney General's office nor we were aware of the Caldwell decision at the time, but having found the Caldwell decision and looked at it, it's directly on point, it's fine.
All right. Any other questions, Commissioners? So just to clarify, your position is there's two different types of investigations. There's one when a verified third-party complaint is filed. And in that context, the commission staff can issue subpoenas without a probable cause finding by the commission. And then there are investigations which the commission staff initiate on their own cognizance. And in those instances, before the investigation can commence and the subpoenas can be issued, the commission has to make a probable cause finding.
Yes, sir. I think that's the way the Supreme Court interpreted the law in Caldwell. That's always been our position as well. Yes, sir.
Okay.
Whether that's good policy, that's an argument directed to the legislature.
All right. Mr. Lane?
Thank you, Mr. Chairman. With your permission, may I remain seated?
Sure.
Okay, thank you. Good morning, Commissioners. I'm excited that this is one of the cases in which Mr. Chalmers and I don't have a lot of daylight between us, which is refreshing, because sometimes we tend to be very opposite to one another. There are some slight differences in how we view the facts of this case, and I would take a slight exception with the characterization that commission staff just draft a complaint and start issuing subpoenas immediately. We do a lot more legwork in that. And this case for Mr. Warren began earlier in 2019 after Mr. Amati came on board. We began looking, as he's previously described, a number of cities and counties, and Mr. Warren was one of those officials that got swept up for a preliminary audit. After the initial audit on Mr. Warren's case was done in August 8th of 2019, commission staff issued what's called a notice of inspection, which is a totally separate part of our code, and it does not require any kind of finding by anyone. We can issue a notice of inspection because it's Tuesday. And what that allows us to do is much like the Civil Practice Act's version of a notice of inspection, where you get to go and inspect all of the candidates' bank records related to their campaign. We're not allowed to take records from that inspection, but we're allowed to go through them and see if those records are lining up with their publicly made disclosures that they file in their campaign contribution disclosure reports. So we issued one of those on August 8th, 2019 to Mr. Warren, and he complied. Myself, along with a former staff member, went to Mr. Warren's accountant's office and we poured through his campaign records. We came across a number of issues that we noticed within those disclosures, and we didn't just go from there. We also served voluntary interrogatories upon Mr. Warren and allowed him and his accountant to answer those interrogatories, and we also had discussions with them to have them try and clear up their accounting issues that we had noticed. In those responses to the interrogatories, we found them to be wanting. They didn't really clear up what we had already seen. Considering we received those responses, on October 3rd, the Commission drafted a sua sponte complaint alleging violations of the Act. Now, Mr. Chalmers is correct that in the prayer for relief within that complaint, it says a finding of probable cause by the Commission. I will take responsibility for that. It appears that one of our newer attorneys found one of my old templates from when I began working with the Commission 5 years ago. I can promise you that template will be purged from our system. It should be saying a reasonable basis to believe that the Campaign Finance Act has been violated. I think none of the commissioners currently here were on the commission 5.5 years ago when I began. When Ms. Wetzel and I came on board, the commission was leaderless, so we were a little rudderless. And we would often interchange the term probable cause and reasonable basis to believe that a violation of the Campaign Finance Act has occurred, because the standards are one and the same. It's semantics. So that explains that prayer for relief. Unless the commission wants to know how else the template used to look different 5 years ago. On October 3rd, though, in addition to the complaint, the commission issued 5 subpoenas. One to the Committee to Re-elect Neil Warren, one to the Cobb County Finance Department, one to Center State Bank, which is the campaign depository institution for Mr. Warren's campaign, to the Cobb County Sheriff's Office for personnel records, and then to the Cobb County Youth Museum Incorporated. Now, I will not be addressing the subpoena that was filed with Center State Bank before the commission. Mr. Warren has filed a separate motion to quash in Cobb County Superior Court pursuant to Title VII of the Official Code of Georgia Annotated, which are banking regulations, which gives Mr. Warren a separate avenue to attack that subpoena as a depositor of that institution. So Cobb County Superior Court will be making the initial ruling on that subpoena. As to the remaining 4 subpoenas, Mr. Warren, in his instant motion to quash, has asked this commission to quash all 4 subpoenas. Now, I would respectfully submit to this commission that the Cobb County Youth Museum subpoena and the Cobb County Finance Department subpoenas cannot be quashed simply because Mr. Warren lacks standing to assert any kind of legal argument or defense on behalf of those institutions. He has no privity, he's not an officer or director of those institutions. Also,
Right now, let's just focus.
That's fine. Additionally, the commission knows both of those entities have already responded. So frankly, the motion to quash as to those entities is now moot. Additionally, with the Cobb County Sheriff's Office, no objection has been filed by that entity to date. So I would argue before this commission pursuant to our own administrative rules, that objection has been waived. As the commission is well aware, we have adopted procedural rules governing all preliminary actions regarding subpoenas. There is a 10 business day, it comes out to 14 days, in which they have to respond. Their response has been given. So that leaves us with just Mr. Warren's subpoena, or the subpoena to his campaign committee. Now, in Mr. Warren's motion, I'm not sure if he's abandoning those claims now because they were not addressed. He raises the defense that they are unreasonable, they're overly burdensome, they're oppressive. Since they were not addressed, I'll operate under the assumption that his arguments have been abandoned, but what I can tell you,
They have not been abandoned, I just wanted to focus.
Right now, let's just focus on the first prong, which is whether the commission staff can issue.
yes, sir. Now, turning to how cases begin, Mr. Chalmers is correct that there are two types of cases. You have third-party complaints, and then you have cases that are sua sponte started by commission staff. We agree. Where we disagree is when you look at Code Section 2156, subsection B9. That section lists out 4 ways that a commission case comes about. And it states, in pertinent part, the commission has the authority to initiate investigations of any statement and reports filed under the Act.
And what section was that?
It's 2156, subsection B9. B is in boy. And I'm going to summarize it unless the commission would prefer that I read it. But the commission is permitted to make investigations subject to limitations, and is on any statements and reports filed under the Act, any alleged failure to file any statement or reports under the Act, any written complaint filed by any person, so that would be the third party, and I'd argue also commission staff, as we are any person as well. But then additionally, any other information that gives rise to probable cause that a violation of the Act has occurred. And that last part, we would argue to the commission, is a catch-all. It allows the commission to open up investigations on other unenumerated violations of the Act. When you look at Caldwell, I would disagree with Mr. Chalmers that it is completely on point. In fact, I would argue that the case is wholly inopposite to the case before you in Mr. Warren's case. In Caldwell, Mr. Chalmers mentioned, and he's correct, that the then commission, they did not inform the respondent in that case of what charges he was facing. They issued multiple press releases to the media, they issued subpoenas, they conducted a preliminary hearing in which the individual was not allowed to participate, he was not allowed to ask questions of witnesses. Basically, all of his procedural due process rights were violated. And the Supreme Court in Caldwell focused in mainly on those issues. And Mr. Warren in this case has had substantial procedural due process protections because since 2014, this commission has applied the procedural due process protections that are contained with the Administrative Procedure Act to all preliminary actions by commission staff, even though the Administrative Procedures Act does not apply until such time as this commission conducts a preliminary hearing and finds a reasonable basis to believe the Campaign Finance Act has been violated. So we have taken all of those protections, which are the right to know what you're being charged with, i.e. a complaint, the ability to have counsel, the ability to participate and call witnesses, the ability to subpoena witnesses and evidence, and basically confront your accuser. Mr. Warren has all of those rights, and he's had since we've issued that.
Okay, so focusing on the word commission, I mean, to me, that's, I think it's incontrovertible. The commission has the ability on probable cause to commence an investigation on some cognizance. Is the commission the commissioners, or is the commission, does it also include the commission staff? And what authority would you have to support what opinion you have?
Yes, sir. And the only thing to watch out on Caldwell, I'm not sidestepping your question, but in Caldwell, the allegation against the respondent was that he was using state employees that were working for him to campaign on his campaign while they were on state time. That was not a violation of the Campaign Finance Act then. That is a violation of 21.530.2, which did not come into being until 1990. So just keep that in mind.
Yes.
Hold on, I want to get this answer.
As far as the ability, does it include just the commission or commission staff? The commission has the authority pursuant to two code sections. The first being 2156 subsection A7, and the second one's right behind it, 2156 A8. Subsection 7 within that code section grants this commission the ability to promulgate administrative rules, which you did earlier today when you adopted procedural rules for the award of attorney's fees. Because as you know, and as we've discussed before, contained within the code, the commission has the power to assess attorney's fees, but it's silent as to how you go about doing that and what the standard is to find frivolousness. So you have fleshed that out. So the commission found that there was some dispute as to how probable cause is found and who finds it. And that was raised, as the commission has noticed, in the Oxendine case. Slightly different argument, but basically the facts the argument remains the same. Now, if you look at subsection 8, it also holds that the commission has the power to do any and all things necessary and convenient to enable it to perform wholly or adequately its duties and to exercise the power specifically authorized in this chapter. The commission did just that when it promulgated a new rule or amended rule, and it is 189-2-.04.
Do we have that?
You should.
Okay.
You should have copies of commission rules.
Well, please point us to that.
It should be page 12.
Number again?
189-2-.04 should be titled Initiation of Investigations by the Commission.
And it was adopted when?
It would have been adopted effective, it was adopted on December 15, 2015 with an effective date of January 4th, 2016.
2015.
Yes, sir.
So that would explain why in February 2006 that meeting went through a different format.
Correct. What we were also trying to do with the adoption of that rule is because the rule states that the commission has devolved authority to staff when staff finds a reasonable belief that probable cause exists that it may commence investigations into alleged violations of the act. What we're arguing is not that the rule creates, and we're not conceding that the commission must find probable cause when we are investigating reports that are already filed with the commission or reports that should have been filed with the commission. So if someone failed to file a report or failed to disclose something required in that report, we argue that the commission doesn't have to find probable cause. We're already entitled to look. And that's also because contained within the code at 21.536 subsection B, the commission has the duty to inspect all reports filed with the commission. There's no statement that you have to find probable cause before we pull up a candidate's campaign contribution disclosure report and start looking through it. The argument moved by both Mr. Warren and Mr. Oxendine have been that commission staff's not allowed to look at anything until such time as we come before the commission and you find probable cause that authorizes us to go look at even reports that are filed with us. Additionally, there have been arguments that have been raised in this vein that say we get a third-party complaint from John Doe. And John Doe says that Mr. Warren has used sheriff's employees for violation of the Campaign Finance Act. And let's say we're going through that and we see plain violations like exceeding contribution limits. According to Mr. Warren's line of argument...
1 second, Mr.
Sure,
Lane.
sorry.
Commissioner Watts.
So just looking at the rule you pointed us to,
Yes, sir.
189-2-104, the chairman's question still stands, I think, because the first sentence says the commission may initiate on probable cause an investigation into suspected violations of laws and rules under its jurisdiction as it deems necessary. Now, the remainder of the paragraph in the rule talks about what the commission staff can do thereafter, which to me seems to appear that the commission versus the commission staff is a different term. And so if you're looking back at the law, which I think is 2156B9, it says that the commission may issue a finding of probable cause, if I'm stating that somewhat correct. When you look at Caldwell, which we didn't have during the Option 9 case, unfortunately, says the act provides that the commission shall not initiate any investigation unless based upon a verified complaint or based upon a finding of probable cause by the commission. So, I mean, you're going to have to reconcile what commission and commission staff mean, because they're two different terms, even in the rule you just pointed me to.
Well, in the rule that I pointed to, and I'm hoping you have a current rule that's published in 2016, it starts off, commission staff, when it discovers or learns of evidence of violations of Campaign Finance Act or other statute within its jurisdiction, the commission may have occurred, may initiate on reasonable belief that probable cause exists, an investigation with respect to violations of laws and rules under its jurisdiction as it deems necessary.
So, I'm not sure that we have that, because the version that I have says effective January 1, 2014, and then it's blacked out. And what I just read to you is, remind me the number, 189?
189-2-.04. You may have old rules. That might explain the problem.
So I must have been reading a different version.
So this seems to be what it comes down to. The code section stipulates that the commission shall not be encumbered their right to commence investigations with probable cause.
Correct.
Hold on. There may have been ambiguity as to what commission was. Because there was ambiguity, the commission in 2015 adopted a rule which addressed that ambiguity.
Correct.
Which is 18-2-.04. That rule, which addressed the ambiguity, clearly defined commission staff as having the ability to do it. So the question is whether 189-2-.04 is consistent with Caldwell and an enforceable rule. And what would your opinion be and why?
My opinion would be that this commission has the authority to devolve its powers to its staff to allow it to properly function. And you've done that in a number of instances. For example, the issuance of subpoenas. If you actually read the code, which should be...
I get that, but it isn't consistent with Caldwell.
I don't think it's inconsistent with Caldwell.
And why?
Simply because the Supreme Court has not prohibited this commission from devolving its power to its staff, which it's done in a number of other instances.
So I guess...
Additionally, I don't want to claim that Caldwell is just pure dicta, because like I said, their main thrust within Caldwell, when you read the full case, is they're focusing on the procedural due process rights of the respondent. So they're throwing, I won't say they're just throwing it in there, but they're not fleshing out the issue as thoroughly as they probably should have.
Now, I understand that that wasn't at issue in that case, the definition of commission versus commission staff. But is it your position that regardless of the term commission used in Caldwell, that the commission sitting up here, that's how we're going to define it, can then under 2156A, 7, and 8 adopt rules to then allow the commission staff to carry out certain functions of the commission?
Yes, sir. And I'd also point out that subsection D9, where it's listing the types of cases that there are, that on probable cause is the catch-all for the commission to investigate unenumerated violations of the Act. When it is related to the filing of a report, when it is related to the failure to file a report. It is our position, and the Attorney General's office has backed that position, and we've argued it at both the Superior Court, Federal Court, and then the Court of Appeals and Supreme Court, and they've all found in our favor, that when it's those first two, so you really have four ways to get a complaint. With the first two, there's no finding of probable cause needed. Then, if you have the third-party complaint, there's no finding of probable cause needed. And then when you get to the fourth one, as you did in Caldwell, when the then commission said the violation is using government employees to campaign. That wasn't a violation of campaign finance back then. It is now enumerated as of 1990 as a violation for 30.2. So in Caldwell, the commission would have had to find probable cause because there was no enumerated violation. They were, I don't want to say they were inventing it out of whole cloth, but they were trying to enforce the then written code which did regulate government contributions, but not in the way that they were seeking to do it. If that,
Well, it doesn't, I mean,
so they were trying to do number 4 as opposed to 1 through 3, is how they were
which is
trying.
what we're doing here.
No, we're not. Mr. Warren's disclosures, in the complaint, we've alleged that he has converted funds for personal use. We basically say he's improperly used funds, and it's because in his campaign reports, he cites petty cash disbursements. And then when you look at the petty cash disbursements, they are to expenses that on their face are not ordinary and necessary campaign expenses. And that's what he's been charged with. So we're alleging one of two things. He's violated subsection A, which is they're not ordinary and necessary campaign expenses. So we're saying that they're in excess of what a campaign would be normally spending. Or there's subsection C, which is they've been converted for personal use. Without having the bank records, we don't know which one it is. So we've done alternative pleading. It's A or C or both.
All right.
So we actually fall under, we argue 1 and potentially number 2, because there are items that should have been disclosed that were not disclosed.
Got it. So here's my thoughts, and then we'll hear from Mr. Chalmers. It seems to me that both the Caldwell case and the 2006 case was before 2015.
Correct.
The commission does have the ability to designate its duties and responsibilities to the commission staff, which makes sense, because otherwise it gets unworkable. If every single time we had to call a special meeting to issue any subpoena, it's going to greatly debilitate the commission staff to do their job, which we don't want to do. And I think more than likely that's the reason why the 2015 rule was adopted. So to me, it goes down to there is a clear rule and point. The rule does enable the commission staff, if they find reasonable grounds, to initiate an investigation. Is this rule consistent with Georgia jurisprudence? Your position is, in Caldwell, it's distinguishable because in that instance, the respondent did not have the same opportunities to present his case, have notice to present his case like Sheriff Warren did here. And therefore, the same constitutional violations that were implicated in Caldwell are not implicated here. Is that right?
Correct.
Okay. Commissioners, any other? All right, Mr. Chalmers, if you want to respond.
Yes, sir. Thank you for the opportunity. A couple of points, and I'll try to keep this brief. First off, on the question of what is the commission versus what is the commission staff, Caldwell said that there must be a finding of probable cause by the commission. As we started off in our presentation, this is a quasi-criminal law. It must be strictly construed. Does it make sense? Is it a reasonable interpretation of the act to say that the commission is the commission and the members rather than the staff? Absolutely.
So just focus on 189 for me, which says the commission staff can.
Understand, but Mr. Chairman, this agency, and just like any administrative agency, lacks the authority to adopt rules that are contradicted by a statute. In this case, we are dealing with a statute that has been adopted by the General Assembly and interpreted
So
by
how
the
does it
Supreme Court.
contradict?
Because the commission, the Supreme Court has said that there must be a finding of probable cause by the commission. Two issues with respect to the rule. Number one, the rule purports to delegate that responsibility to the staff. By that reasoning, the staff could also make a determination about whether or not there are reasonable grounds to believe there's been a violation and move forward at the preliminary hearing stage. By that reasoning, the commission staff itself could be delegated the power by this commission to decide whether to impose penalties. Respectfully submit that is not what the statute permits. It's not what the Supreme Court said. There are also reasons why we don't do that. It's important to remember that that at the preliminary stage of these proceedings, the commission staff is a litigant. The commission staff is the one who filed the complaint in this case. Due process requires that and the statute requires that the finding of probable cause be made by an independent, objective, neutral observer, which is the commission members. Just as a reminder, in August, the commission staff had filed a complaint against one of our clients, and the commission members dismissed one of those allegations as a matter of law because it's improperly interpreted the act. That establishes, I think, pretty clearly why we need the commission to make the finding of probable cause. The commission staff cannot be the ones to file the complaint, and then when they are an active party trying to convince the commission members to do something, have the independent authority to determine whether or not there is probable cause to investigate that complaint. You cannot be a judge in your own case. The commission members in this case are the judge. And so I would respectfully submit to you that that's improper. The commission rules themselves, which was adopted, differentiates between the commission and the commission staff. If in fact the law was that the commission is the staff or vice versa, they are absolutely one and the same, why would it be necessary to adopt a rule passing a certain power to the staff? And under Georgia law, it is improper for an administrative agency to have a law that conflicts, a rule or regulation that conflicts with a law of general application. That's the Supreme Court.
Do you agree, is it your position that the commission can delegate its duties and responsibilities to the commission staff?
I don't think that there's any clear law on that. And so the answer
is there clear law on that?
The provisions contained with subsections A7 and A8 under 2156 gives you the power to adopt those rules.
Neither one of those things says delegates to the staff. A8 simply says the commission may adopt rules and regulations. That's always the case for an administrative agency. What what the Supreme Court has said is the administrative agency cannot adopt rules and regulations that exceed the scope of the agency's statutory authority. Nothing in A8 says anything about delegation.
Right.
So have you, since Caldwell, have you litigated this issue, particularly this rule, in any of the Georgia courts?
No, sir. This is the first opportunity this court that the commission has had. We do, as Mr. Lane pointed out, the provisions of the banking code require that any depositor whose bank records have been sought by an administrative agency having jurisdiction over the depositor file a separate motion to quash in the Superior Court. So with respect to the subpoena that was issued to Center State Bank, which is the bank which holds the campaign's financial records, we have a motion to quash pending in that case. The commission's response is not due till Wednesday. That issue will be litigated there separately, and obviously depending on how this commission decides to rule will affect the outcome of that case. The other thing that's important to keep in mind is that the distinction that Mr. Lane has made with respect to the four different parts of investigative authority, as we pointed out in the beginning of our argument, all of those four prongs were in the statute at the time. Caldwell did not differentiate between them, did not make any statement that you don't have to find probable cause to look at the reports. Mr. Lane also makes the argument that we are trying to prevent the commission staff from even looking at disclosure reports. That's not what we're doing. If you notice that the minutes of the 2006 hearing, the way that went was that Mr. Lee, Teddy Lee, I'm the executive secretary, said that the commission staff hadn't looked at the disclosure reports that had been filed, which is the first of the four prongs that Mr. Lane mentioned. And after having looked at those disclosure reports and identified certain problematic, certain issues that they were worried about, they went to the commission after having looked at those reports for a finding of probable cause to investigate and issue subpoenas. So to the extent Mr. Lane is arguing that only probable cause only has to be found for the fourth of those four prongs, that's not what the Supreme Court said. That's not how the commission interpreted this for 25 years. And I respectfully submit that the nominated supports it.
Thank you. So are you saying that Commission Rule 189-2-.0404 is not valid?
Yes, sir. And not only is it not valid because it delegates to the staff a power that the commission itself has to hold itself, And number two, even if the delegation issue is ruled against us, even if the commission or the courts decide that the commission can delegate any of these decisions to the staff, this rule doesn't require a finding of probable cause. It's important to note that nowhere in Mr. Lane's argument did he contend that the staff had made a finding of probable cause. The argument is that it does not have to be such a finding. That's not what the Supreme Court said in Caldwell.
Yeah. All right. Any other questions? Well, my thoughts, and I'll make a motion, I'll put my head out there. I think that the commission can delegate its duties and responsibilities to the commission staff. I think that if we had to go forward with a full-on probable cause hearing to initiate any subpoena, it'd be simply unworkable and debilitate the commission staff. I think there is a valid or a rule that has been passed, and I think the commission has to respect that rule. I think Mr. Warren, should he want to challenge the constitutionality of that rule under the Caldwell case, he's got every opportunity to do that, and if Rule 189.2-.04 gets struck down, we will change whether we abide by that rule, but if and until that goes forward, I think we have to respect that rule, and given that, I would move to deny the motion, or not, well, first, that's issue one, because you also, Mr. Chalmers, have concerns about modifying or limiting the breadth of the subpoena.
Yes, sir, that's correct. I'm perfectly happy I think it's important to create the record. If the commission wishes to vote now on the question of whether or not there needs to be a finding of probable cause for it to initiate an investigation, I think that you can and probably should rule on that issue. And then if in fact our argument there is rejected, then we can talk about the other grounds of the subpoena, if that makes sense.
That's an important point. So we're here on the motion to quash. We're not here on an advisory opinion. I don't know if you can request those from us candidly. We can request them from the AG's office. But we're ruling on the motion to quash.
Yes, sir.
So I'm not entirely sure it's appropriate to just start taking separate votes. I know what you want, and I understand what you want, and that's fine. I'm not faulting that. But I don't think it's appropriate for us to just start making new rules along the way when what's pending is a motion to quash.
Which one you want?
I mean, I'll agree with that point, Mr. Chalmers. If you want to go ahead and propose, or make your additional arguments, then go ahead. But I think that the question before us is going to be, whether or not to grant or to deny your motion to quash,
Yes, sir.
and not to provide you with, I know what you're looking for. Again, as Commissioner Watts indicated, but
But the only reason I raised it, Commissioner, was because if in fact you grant the motion to quash on the basis of the finding of probable cause, we can save everybody some time without me having to raise these other arguments. And that's the only reason I raised it, because only Commissioner Evans so far has expressed an opinion on that issue.
do you have any additional arguments? Are there any additional points you want to bring up in regard to these other arguments that you haven't already addressed that aren't covered in what you submitted to us in writing?
No, sir, not on the finding of probable cause. If the commission is going to rule against me on the finding of probable cause, I would like the opportunity to address the scope of the subpoenas.
That's actually what I was talking about. With regard to scope, are there additional arguments that you want to make here
Yes, sir.
as part of oral argument that's not covered in what you've already submitted to us in writing?
Yes, sir. There are. One of the things, and Mr. Chairman, should I move forward with that?
Yes.
Okay.
And Mr. Lane, do you have any comment? Okay, yes.
One of the things that I think is important, that ties sort of back into the finding of probable cause, what exactly is being investigated here? Are we investigating the allegations in this complaint or not? Frankly, it's not very clear. The complaint is a mess. It is 6-7 pages long of individual expenditures, and every single one of those expenditures is alleged was not ordinary and necessary expenditure, and not one time does it say why. There is no explanation about why given expenses were improper. For example, some of these expenditures were expenditures for office supplies and office food and beverages for the sheriff's office staff in the sheriff's office. It's alleged that that's a violation of the law because they were not campaign expenses. campaign funds may legally be used for ordinary and necessary expenses related to the fulfillment of office. It is quite common for public officials to do that. In any event, we're going to take a lot of time going through these individual allegations, but the subpoenas that have been issued don't investigate those issues. They're looking at other things. So, for example,
And just pause 1 second. Have you guys tried to work out the breadth of the subpoena together? And you just came to an impasse?
My understanding, there's not been a conference to see if we can narrow the scope.
no, we've spent our time talking about the finding of probable cause.
Okay. Would it be productive to do that?
I'm not entirely sure it would be, because the subpoenas are fairly limited in scope, and they are seeking records that relate solely to campaign activity. It's not like we're asking for personal bank records.
I'm going to object to that characterization. The response itself says it's a very limited scope. The subpoena to the campaign committee requests all banking and other records related to every single expenditure made by this campaign committee for nearly a 6-year period. That is not limited in scope. The subpoena also, and this is sort of also goes back to the finding of probable cause and ties this in pretty closely with Caldwell as well, even under Mr. Lane's theory. The commission has issued a subpoena to the Cobb County Youth Museum. And in that subpoena, it requested copies of any financial records related to financial
Is
transactions.
that the one that was already produced?
It is.
Between the Youth Museum and Sheriff Warren's personal account. How in the world does that have anything to do within the jurisdiction of the commission?
But that one's mooted, right?
It's not mooted, no, Your Honor. Your Honor, Mr. Chairman, it's not mooted because we filed a motion to quash that subpoena before the date of production of the subpoena. The commission's rules that were adopted only apply a 10-day deadline to the person to whom the subpoena was issued. And we've got plenty of precedent from prior cases where the commission has allowed respondents to file motions to quash subpoenas served to third parties. So I respectfully submit it's not mooted.
Yeah, I understand. But limiting these is going to be, for us, very onerous, because unless you've got in short form, this is how I propose limiting. Have you done that, or it just says this is the revisions that I want?
No, sir, I haven't, because I don't think the commission has jurisdiction even to investigate that issue. We're talking about financial transactions between our client's personal accounts and the Youth Museum, a 501c3 charity for which he has raised tens of thousands of dollars over the past 5 or 6 years. How does that fall within the scope of the commission's jurisdiction? And how is it appropriate for us to narrow a subpoena down so that's appropriate? I don't see how we can do that.
Mr. Lane?
Two things, Mr. Chairman. The first one, as far as the length of time, under Code Section 21532, Mr. Warren by law is required to keep his banking records for the period of time that we've sought. We've also gone a year beyond the period of time he's required to keep it, just so we have a baseline, so we are capable of doing the accounting appropriately, just to make sure that we're not dinging him for something that would otherwise be appropriate.
I'm sorry, did you say you went 1 year beyond?
If I remember correctly, this subpoena, I believe it goes all the way back to 2014.
January 1 of 2014, which was nearly 6 years ago.
Correct. But the statute of limitations is 5 years. So we've gone 1 year beyond the statute of limitations just so we have a baseline for our accounting. We don't want to accuse him of doing something incorrect in the other 5 years. Now, if the commission wants to limit it to just within the 5 years that 21532 requires them to keep the records.
I guess my question is, why would we go beyond something that you obviously know that our jurisdiction is only 5 years.
Correct.
Why would you go 1 year more?
Because he raised money during that period of time that he would spend in subsequent years. So we're trying to see where the money came from.
This is why there needs to be probable cause.
It could,
That wouldn't even matter.
it would if he's done separate accounting. It would.
How would we have jurisdiction if, I don't care how you raised it 6 years ago, we only have jurisdiction for 5 years.
We're not alleging, we wouldn't be alleging like at the 6 year mark, he raised too much money. I'm just gonna do hypothetical, I'm not saying this is his case, but in the 6 years, say he raised too much money. We wouldn't allege that because it's barred. But he kept the money until year 4, and then he spent money. That also constitutes a violation if you were spending the money outside of the election for which it was raised, if that makes sense. It could be a violation in year 4. So,
Mr. Chairman, that's exactly why the commission needs to have a supervision of the staff and a finding of probable cause. The staff just
We're
admitted-
past that. All right, Commissioner Watt.
I mean, I think that's in litigation terms, a discovery period versus a,
Correct.
a liability period, which I understand. While I do think that there could be some narrowing, which is going to be up between the parties, I do have a question, particularly with relation to the Cobb County Youth Museum and, not Center State, what was the other one?
the Cobb County Finance Department?
Yeah. Explain to me why Sheriff Warren has standing to challenge those two.
Yes, sir. First off, on the standing issue, the commission staff's argument that we don't have standing is supported by absolutely no authority whatsoever. I think that's important to note. Second off, the standing argument conflicts with the commission's precedent. In 2016, we litigated a related issue in case 2009-0007, which was the Oxendine case, and this commission, prior commission, issued an order on January 28, 2016, granting our motion to quash a subpoena issued by the commission to a third party, the bank. That was a precedent establishing standing for third parties.
But that's not, let's go back, because I agree with your point that you made earlier about the customer or depositor under Georgia law has to step in. That's why I didn't ask about Center State Bank. I'm asking about the other parties.
I understand that, but I'm establishing that that case does in fact show standing for a litigant before the commission to file a motion to quash before the commission as to a subpoena issued by the commission to a third party. That was Mr. Lane will argue that was a one-off and a unique situation, because what happened was the staff didn't provide notice to Mr. Oxendine before it served the subpoena on the bank and got the records. In that circumstance, they subsequently quashed it when we filed a motion to quash. That's still nonetheless on the standing issue. That still establishes the circumstances where that has been permitted. Third point on that issue, let me just finish. The third point is the commission itself has taken that position itself in litigation. Back in 2013, on April 3rd, 2013, the Attorney General's office, acting on behalf of the commission, filed a motion to quash in the Culberman lawsuit that was going on with Stacey Culberman, the former executive secretary in the Fulton County Superior Court. In that motion to quash, the commission took the position that subpoenas that had been issued by Ms. Culberman to third parties should be quashed. It took the position that it itself had standing to make that argument. Now, I recognize that's a Superior Court case, but the commission has oftentimes relied on those sorts of rationales in circumstances where the Campaign Finance Act is silent. So I respectfully submit we do have standing, and if you're going to adopt a standing standard that shows we have to have some interest, clearly Mr. Warren has an interest in records of his personal financial transactions with the 501c3. There's privity there, there's a direct interest that is affected by that. That alone under the state case law would allow for standing for somebody to seek to quash a subpoena.
So what, Mr. Lane, what's the standard to quash a subpoena or modify it?
The standard in Georgia is unreasonable, overly oppressive, burdensome.
Okay.
And again, that's not in the Campaign Finance Act, that's extrapolating from something else.
Mm-hmm. So I'm
Are you advocating for a different standard?
I'm sorry?
Are you advocating for a different standard?
No, I'm basically making the point that in response to the question about standing, Mr.
No,
Lane,
the standard for granting the motion to quash. You said that he took that from some other.
I'm drawing by analogy. Mr. Lane made the argument that we lack standing, and he's relying on part of the fact that there's nothing in the Campaign Finance Act that says we do have standing. My argument is that there are other circumstances and other cases where principles from the Civil Practice Act or principles from the motion to quash standard are applied by the Commission in the absence of anything else. Under those standards, standing, we have the ability to file these motions to quash.
All right. But we've got to keep moving along. So we could talk about all these philosophical issues all day long. The issue is the extent to which the subpoena is unreasonably oppressive. This is an initial preliminary investigation. I would expect that to the extent possible, all the documents, their confidentiality is maintained. I'm sure the commissioners would greatly appreciate if you guys could try to work it out and limit it. Is that just not something that would be productive, or are we just going to be forced to make a call?
We can always try.
On issues that are within the commission's jurisdiction to investigate, clearly might be productive. On issues like the Cobb County Youth Museum and investigating those transactions, I don't know that narrowing it would be productive, because our argument is there's no jurisdiction to investigate that anyway.
Okay. What do the commissioners say? Is it productive to get these guys together in a room, or do we just make a call?
This might help the commission in this decision. The records that have been produced by the Cobb County Youth Museum, and I can answer Mr. Chalmers' question of how do we have jurisdiction on the documents we've gotten, and how does that relate to the Campaign Finance Act. That may not be documents that the commission or Mr. Chalmers' next client want released at this moment, because in order to make that argument successfully, we would have to start releasing some of the documents we've already received so you can see how it interplays with the Campaign Finance Act. So just as an FYI.
Thoughts?
So it doesn't sound like from either one of you that you're going to get anywhere if you go to a room and try to work it out.
If the commission staff wants to narrow the scope of the commission, of the subpoena to the campaign the campaign committee, happy to have them do that. Right now, they're asking for every single expenditure we've ever done.
What's the problem with that?
Number one, there's
Through the campaign, isn't that right? What the staff is asking is records of every expenditure through the campaign.
correct.
What's wrong with that?
Going back in part to the finding of probable cause, there needs to be some basis to investigate this before you make a candidate or an elected official spend hours and hours and hours organizing files, duplicating files, when there's been no reason to investigate them at all. One of the reasons you just adopted, the legislature adopted the rule on attorney's fees, was to prevent people from having to go through the political difficulties of having complaints filed against them and then having to spend months responding to them. The same thing applies here. This is a public case, public investigation, and there's been no basis to investigate all these expenditures. And we respectfully submit that the allegations themselves that are being investigated mistake the law. So I think that it's worthwhile for us to see if we can narrow the scope of that so we don't have to have every single expenditure reviewed over a 6-year period.
So, Mr. Chairman, I have a question for the commission, for you, or maybe the Attorney General. We're ruling on a motion to quash, but now we're talking about potentially not ruling on that motion until we subdivide some of the other parts?
But we can modify it as well. So he's moving to quash it or modify it.
Well, and forgive me on this one, as to mootness. The fact that Mr. Chalmers filed timely doesn't change the mootness aspect. What's the purpose of modifying a subpoena that the Youth Museum has already properly complied with?
Well, I agree with Mr. Chalmers on that point. A party can improperly respond to a subpoena, and if the party improperly responds, those documents cannot be used against that party. So I'm okay with that. The question the commissioners have to make is we have to decide, are we going to piecemeal modify it?
May I make one observation for the record, Mr. Chairman? I think you just stated that our motion is a motion to quash or modify. To clarify, it's a motion to quash.
Okay. Have you not requested modification?
No, sir.
Okay.
And
Well, that simplifies it.
If in fact,
We're just ruling on whether or not to quash the motion, so we can't subdivide. Is that?
if in fact the commission staff wants to talk about modifying some of the subpoenas, we can talk about that. But our motion was a motion to quash, and I think for purposes of this issue, creating the record more cleanly on that makes more sense.
Okay. Well, given that, based upon the reasons that I made earlier and the fact that it is just a motion to quash, I'll make the motion to deny Mr. Warren's motion to quash.
I'll say.
We've got a motion, we got a second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? So the motion carries 4-0. So let's do a very quick wet restroom break, and then we will do the next one on the agenda. And time, so we will take a very brief 5-minute break and we'll be back. Thank you, guys. Started? Or good? Okay. Getting back to order. The next thing we have on the agenda is in the matter of the New Georgia Project and New Georgia Project Action Fund. Before we get to that, real quickly, do we have anyone that's in attendance for the preliminary hearings? No. Okay. Well, good. One?
There's another one.
Okay. And for this one, how long do we anticipate it taking?
I anticipate about 10 minutes. And
10
then I'd
minutes.
like
Mr.
to,
Chalmers, 10 minutes?
I would like to have some time for rebuttal.
Mr. Chalmers, 10 minutes turned into 40 minutes, which we're accustomed to at this point. We've already priced that in. And who on behalf of the commission staff is?
I will, Mr. Chairman.
Okay, how long?
Depends on how hot the bench is, but
Okay.
I think my presentation will be 15 to 20 minutes at max.
Okay. And I'll ask you guys the same question I asked the previous one. Have you guys attempted to work out the scope? Would that be productive in any way?
I don't think so.
Okay. All right, and please state your name for the record.
Sure. Good afternoon, Commissioners. My name is Aria Branch. I'm from the law firm of Perkins Coie, and I represent New Georgia Project Incorporated and New Georgia Project Action Fund. The Commission has issued subpoenas to New Georgia Project Incorporated and New Georgia Project Action Fund pursuant to an investigation it has initiated on its own, which contains 2 allegations. The first is that both organizations were required to register and report as campaign committees, specifically ballot question committees under the Act. And the second is that both organizations were required to register and report as independent committees under the Act. It is our position that the subpoenas should be quashed for the reasons described in our motion and our response to the Commission's complaint, and for the reasons I will describe here today. Specifically, that the Commission lacks probable cause to initiate the investigation, and the requests in the subpoenas, if required to disclose those documents requested, would violate my client's First Amendment rights, as well as those individuals and associations who associate with our clients. For ease of reference today, I'll refer to New Georgia Project Incorporated, which is a 501c3 public charity recognized by the IRS as such, as simply the C3. And I will refer to New Georgia Project Action Fund, which is a 501c4 corporation, as simply the C4. I hope that will make it easier to keep the 2 organizations separate, which they are. So the first reason the subpoenas should be quashed is that the Commission lacks probable cause to investigate either organization. With respect to the C3, there's no allegation in the complaint, not a single fact, to support the Commission's assertion that the C3 was required to register as a committee. Now, the Commission has gotten a preview of the history of its rules, but it is clear under the Commission's own rules that it is required to have probable cause in order to initiate an investigation. This is similar to the matter that was discussed earlier. The Commission has initiated this investigation on its own, not pursuant to a third-party complaint. The Commission's rules also require it to provide notice to respondents that provide the basis for the Commission's finding of probable cause. Here we received a complaint, and we assume that that is the Commission's notice of the basis for finding probable cause. Now, the Georgia Court of Appeals held in a case called McGonigal versus Treadwell that the probable cause standard means the existence of such facts and circumstances that would excite a reasonable mind to believe that a violation of the law has occurred.
And what was the case site on that one?
That is 216 Georgia App 850. The page number is 854. And that's McGonigal versus Treadwell. With respect to the C3, there simply is no probable cause. The complaint does not contain a single fact or allegation to support its assertion that the C3 was required to register as a committee. In fact, the only factual allegation in the complaint that asserts that either organization was required to register comes in paragraph 15 of the complaint, which alleges that the organizations, quote, engaged in canvassing of neighborhoods throughout Georgia. The rest of the complaint is simply a bare recitation of the definitions of committees under Georgia law and the legal standards for registration and reporting. The complaint also cites to a number of exhibits to support its assertion that the organizations engaged in the canvassing of neighborhoods. All of those exhibits, with the exception of 2, are social media posts that were made by the 501c4 organization, which is New Georgia Project Action Fund. There is not a single fact or allegation related to the 501c3 organization. The 2 exhibits that are related to the C3 are a post of the C3's mission, which provides that it engages in nonpartisan activity, which is true. It engages in activity to register voters of color throughout Georgia, and it is done on a nonpartisan basis. The other exhibit that relates to the C3 is simply a link between the C3 and C4 websites that provides that the C3 engages in nonpartisan activity. None of that activity is within the scope of the Commission's jurisdiction, and there's no allegation in the complaint that would support registration for the C3. And that's for good reason. The C3 and the C4 are separate organizations. They have different missions. As I stated, the C3 engages in nonpartisan voter registration and voter education for Georgians and individuals of color in the state. The C3 did not engage in any electoral activity with respect to the 2018 or 2019 elections. It didn't engage in any expenditures to support or oppose a candidate, and it didn't engage in any expenditures to support or oppose a ballot measure in Gwinnett County. Those are the only 2 allegations in the complaint. The C3 didn't engage in that activity, and there are no allegations in the complaint to the contrary. The complaint and the Commission simply have not met the probable cause standard with respect to the C3. The complaint appears to put the 2 organizations together, and that is improper. They're separate corporations with separate mission statements, separate governance, and the C3 simply has not engaged in any activity that is subject to the scope of the jurisdiction of the Commission. With respect to the C4 organization, the subpoena also lacks probable cause with respect to the C4 because the facts that are alleged in the complaint are simply not sufficient to require registration under the Act. The C4 was acting as a vendor with respect to the 2018 statewide election. It was hired by 2 registered independent committees in Georgia to engage in canvassing on their behalf. And I can submit the fee-for-service agreements that were entered into between the C4 and Power Back Georgia, which is one of the campaign committees that the C4 engaged in canvassing on behalf of. Under Georgia law, an independent committee is defined as a group of persons or an other organization that accepts donations from members or supporters of the committee and then expends those funds to advocate for the election or defeat of a candidate. Here, the C4 simply did not meet that definition with respect to the 2018 election. As I said, the C4 was hired by 2 registered independent committees to engage in canvassing on their behalf. They received fees for services from those 2 independent committees. They were not donations from members or supporters of the C4. Further, the C4 did not make expenditures on its own to engage in canvassing. The independent committees that paid the C4 are the ones that engaged in the expenditures. It was their activity, and the C4 merely carried it out, acting as a commercial vendor for commercial purposes. And if I may, I would like to submit to the Commission copies of the fee-for-services agreements that were entered into between the C4 and Power Pack Georgia for both the primary and general elections in 2018.
Sure, if you could just, Mr. Fuller will grab that from you and he'll. That's the easiest way to do it. Our attorney.
Thank you. As you can see in those agreements, the C4 New Georgia Project Action Fund was hired to engage in canvassing as an independent contractor on behalf of Power Pack Georgia. It did engage in canvassing to support or oppose Stacey Abrams, but it wasn't actually the C4's activity. It was merely a vendor, and vendors are not required to register as independent committees under Georgia law. If that were the case, every media vendor, every canvassing vendor, every social media vendor would also be registered as a committee. And the C4 acted very similarly to typical consulting paid vendors. Moreover, going back to the definition of an independent committee, it's defined as an individual or organization that accepts donations from members or supporters of the committee. Here, the C4 accepted fees. Fees for services are not donations from members or supporters under the Act. And I would also submit to you that the canvassing scripts that were carried by the New Georgia Project Action Fund canvassers contained a disclaimer that said paid for by Power Pack Georgia. And the reason for that is because the expenditure for the campaign for the canvassing activity was made by Power Pack Georgia, not by the C4. Because the C4 acted as a vendor, with respect to the 2018 election, the commission does not have probable cause to pursue an investigation of it. The third reason the subpoenas should be quashed is because both subpoenas issued to both the C3 and the C4 seek documents that are clearly protected by the First Amendment privilege. The Supreme Court has held in NAACP versus Patterson, and several circuit courts of appeals have held that organizations that engage in civic and political advocacy are protected by the First Amendment from having to disclose the inner workings of their organizations. This is not limited to certain types of documents. This is a broad protection that operates to protect documents that, if disclosed, would have a deterrent effect on the engagement in protected activities. In the NAACP versus Alabama case, the state of Alabama was seeking membership lists from the NAACP to help it with an allegation that the NAACP had failed to register as a corporation doing business in Alabama. And the NAACP refused to produce copies of their membership lists, arguing that they were protected by the First Amendment. If they had to produce lists of all of their members and people who affiliated with the organization and were supporters of the organization, that would quell political speech. It would chill speech, and that's protected under the First Amendment. This case is very similar. Here, New Georgia Project and New Georgia Project Action Fund are engaged in some political, well, New Georgia Project, the C3, is not engaged in any political activity, but is engaged in advocacy and civic advocacy on behalf of Black voters in Georgia, to get them involved in the political process, to get them registered to vote, to educate them about the political process. If they are required to essentially open their books to the commission for a full audit without probable cause, that will quell political speech. Here you'll see the documents sought by the subpoenas are clearly protected by the First Amendment. They seek bank records, every single bank record.
So would bank records, in your opinion, be political speech?
I think that the information that is included in bank records, yes. I mean, it's similar to the NAACP, they had to disclose membership lists. The bank records of these organizations will disclose their donors. It will disclose individuals who have been paid by New Georgia Project and New Georgia Project Action Fund. It will disclose every individual organization and association that has affiliated with the C3 and the C4 since the beginning of time of these organizations. These subpoenas request bank records going back to 2017, despite that there is not a single allegation in the complaint related to them having engaged in any activity in 2017.
All right, Commissioner Wise.
So, but under that theory, then, it would be a completely unregulated entity.
Well, I would argue that's not the case. I mean, I do think that if the commission has probable cause to seek bank records that are related to any expenditure or contribution made in Georgia with respect to the 2018 and 2019 elections, I think that is more in the ballgame. But here, you're seeking documents related to every single expenditure, every payment, every check, every deposit slip, every check register that these organizations have engaged in, despite the fact that they are 501c3 and C4 organizations that are not within the scope of the commission's jurisdiction. They're not required to disclose their donors, and they primarily, the C3 engages in no political activity, and the C4 engages in primarily non-political activity. So most of the expenditures contained in their bank records are not related to anything that the commission regulates.
So I guess what I'm having a hard time understanding is that if the commission staff can't go through the records to determine what is and what isn't political or what isn't part of its jurisdiction, who makes that call?
Well, I mean, the courts have said that this is the type of information that is protected by the First Amendment. The 6th Circuit, the DC Circuit, the 10th Circuit, and the Supreme Court have all said that once a respondent from a discovery request or a subpoena demonstrates that the requests are arguably within the scope of the First Amendment, then the burden shifts to the government, or in this case the commission, to prove that it can meet a heightened burden, which would be that the documents sought are crucial to their inquiry or related to a compelling state interest. And I would argue there is no probable cause here. The commission has not met that heightened burden, and I don't think that it can, given that these organizations engage in the C3 is engaged in no political activity, and there's not a single allegation in the complaint alleging that it has. And the C4 engages in occasional political activity, but its purpose is primarily nonpartisan and related to voter education and voter registration on a nonpartisan basis.
So, but it's your position that if they were to meet the probable cause standard, then the First Amendment would not be violated?
No,
by looking at these bank records.
It's my position that the First Amendment is implicated by the records that are being sought by the commission. And therefore, under Supreme Court precedent, they need to meet a heightened burden of scrutiny. They need to show that the documents and records they seek are related to a compelling state interest. And I don't think the commission has made that allegation in the complaint, and I don't think that it can.
And that is, so you're claiming the First Amendment privilege to every document that's sought?
No, not every document that's been sought. Specifically with respect to bank records, which would disclose, as I mentioned before, donors, every individual who affiliates with the organization, who's been paid by the organization, every expenditure that these organizations have made since the beginning of time. Those documents are clearly protected by the First Amendment. The subpoena is also extremely overbroad, and it appears to seek, I think, communications related to a bunch of different topics, including IRS documents, documents related to the organization's PO box, which I don't think are within the scope of the commission's jurisdiction, and also would be protected by the First Amendment. I think these communications would reveal associations. This is exactly the type of activity that the Supreme Court has said is protected by the First Amendment, because if it is required to be revealed to the commission, it could chill political speech. Moreover, our understanding is that any documents that are turned over to the commission are subject to the Open Records Act. And it appears then that these organizations, if they are required to turn over their bank records, which disclose their donors and every other political and civic affiliation that they have, those documents will be subject to open records requests that any individual in Georgia can seek from the commission. And that that is a violation of the First Amendment.
Is it your position that that in and of itself is a violation of the First Amendment, or the practice tends to quell political speech and participation in your organizations?
I think that the practice would quell political speech with the organizations. And I'll point you to a case from the Ninth Circuit that says that the test is not about the specific records that are being sought and whether they violate the First Amendment. The test is whether the documents sought would have a deterrent effect on First Amendment rights and would chill political speech. And courts have held that if you make the argument that documents sought by a commission or other government body are protected by the First Amendment, the commission is required to make a higher showing. So it would be our position that if these organizations are required to disclose documents such as their bank records, which are protected by the First Amendment, without the commission having to make a higher burden, this would have deterrent effects on these organizations and would chill political speech. If every time an organization engages in political activity, it can be required to open its books and be subject to a full audit by the commission.
Doesn't that eviscerate the existence of campaign finance laws? I mean, if I am an entity that may or may not be engaged in activity that qualifies me as an independent committee, and a government agency seeks those documents, and I say, nope, can't get the documents, it potentially quells and deters the First Amendment and inhibiting the agency from investigating whether or not they're engaged in activity which subjects them to disclosure, then doesn't that give you an absolute immunity?
I don't think it does. I mean, with respect to the C3, there's no allegation that the C3 has engaged in any activity that would be regulated by the commission. So I think we can put that subpoena aside. I think it should be quashed on that basis. There is not a single exhibit or fact that is specific to the C3 organization. With respect to the C4, the Supreme Court and other courts in this country have said that there is this First Amendment privilege, and it protects organizations that engage in civic advocacy from having to open their books to governmental entities because that would chill political speech. And so I do think it's reasonable if the commission would like to limit the scope of the subpoena to bank records that are specifically related to contributions and expenditures as those terms are defined under the Act. That I do think we would be amenable to considering whether that's within the commission's jurisdiction. But the idea that these organizations have to open their books to the commission without showing a probable cause when these documents are clearly protected by the First Amendment.
But your line, as I understood it earlier, was names of individuals, and that's what's going to quell free speech. Am I right?
I think that's part of it, yeah.
Because what you just said was, if we're going to limit it to contributions, there's going to be a name on the check.
Right.
So how can you reconcile the two, rules you're seeking here?
I think that, we're open to discussing how to narrow or modify the subpoena. I think that if an individual made a contribution to these organizations and it was earmarked for political activity in Georgia, that is arguably within the scope of the commission's jurisdiction, and that interest for the commission's regulation may outweigh the First Amendment concerns. However, the C3 and the C4 receive a lot of unearmarked donations. In fact, most of their contributions are not for the practice of politics in Georgia. They're simply to help voters register and be educated and engage in advocacy in Georgia.
So then what if the C4, put aside the C3 as you say, what if the C4 then takes the unearmarked portion, the general fund, if you will, and uses that for political activity in Georgia? How is the commission staff going to know if they can't start to trace that? And again, taking the check that has a name on it, yet it's unearmarked.
Right. I mean, I think that the commission needs to make it needs to meet the higher burden to show that it needs those documents. And the allegations in the complaint simply have not done that.
Okay.
Again, the subpoenas are overbroad. They seek documents going back to 2017, since the beginning of time of these organizations, despite the fact that they only allegedly engaged in activity related to the 2018 and 2019 elections. The subpoenas also seek documents that are outside the scope of the commission's authority. As has been stated before, the commission has statutory authority over campaign finance matters to enforce campaign finance laws. And the Georgia Court of Appeals has held that an administrative rule which exceeds the scope of or is inconsistent with the authority of a statute upon which it is predicated is invalid. The commission is not entitled to seek documents outside the scope of its authority and outside the scope of campaign finance matters. The subpoenas seek materials related to the organization's PO box, their insurance documents, IRS documents, many of which are publicly available, and incorporation documents, none of which are related to the commission's statutory authority over campaign finance matters. And as I stated before, the requests are broad enough to encompass communications made by the organizations, which we again would argue are subject to the First Amendment privilege. Finally, the definitions of independent committee and campaign committee under Georgia law are unconstitutional. And when you narrow the statutes, the statutory definitions to what the First Amendment allows, there is no probable cause. The Supreme Court has held in Buckley versus Vallejo that registration and reporting statutes and the burdens that are associated with registration and reporting under campaign finance laws can only be applied to organizations that are either controlled by a candidate or, importantly for our purposes here today, have a major purpose of engaging in advocacy related to elections. The Georgia statutes that define independent committee and campaign committee contain no such major purpose requirement. Several states and courts have struck down state statutes similar to the Georgia one, where there is no purpose requirement. If you look at the 4th Circuit in North Carolina versus Leaks, the 10th Circuit, and there are several others where the state statutes that don't have a major purpose requirement are unconstitutional under the First Amendment because they require organizations that merely engage in some political activity but lack a major purpose to be subject to the burdens of registration and reporting under state law. The exhibits in the complaint and the allegations in the complaint merely allege that the C4 may have engaged in some political activity. And as I argued earlier with respect to the 2018 election, it engaged in activity as a vendor on behalf of other committees. But there's no allegation in either the complaint or the exhibits that it was the C4's primary purpose. And that's for good reason, because it was not. So we would submit that the definitions of independent committee and campaign committee are unconstitutional, and when you narrow them to require a major purpose, as the Supreme Court stated in Buckley versus Vallejo, the commission lacks probable cause.
Is that a new ground that you're seeking in your motion to quash? Because I don't see it in the papers.
It's not set forth in detail in the papers, but it is set forth in our response to the complaint, which I can provide a copy of if you would like.
I think I can probably do it for this time.
Mr. Chairman. And I'm very loath to interrupt, I don't want to be rude. I would only point out that we are here for the motion to quash. The constitutional argument regarding the statute was in the response that we received 2 weeks ago. So my only point would be, we'll be prepared to litigate that, but that's not right for debate here today.
Counselor, that's what I was asking. I totally understand that may be a separate issue, but that's not part of the motion to quash, as I understand it from your papers.
Understood. I do think that oral argument is the place where, and there's no requirement in the rules that we can't make arguments that are not separately detailed in our motion.
I 100% agree. I'm just asking for the grounds of your moving on the motion to quash.
Thank you.
All right, Ms. Branch, thank you. And you have reserved opportunity for rebuttal, and you'll have that opportunity. Secretary Amati, whenever you're ready.
And Mr. Chairman, if you could just give me a minute or two to set
Sure.
up. I have a demonstrative aid.
I would just like to say, we shared the same 10 minutes.
I think Secretary Amati said 20 or 30, so I don't know what that would be, Mr. Chalmers.
I'm usually a little better than Doug, right? All right, where is the, that's that. Mr. Chairman, Commissioners, we are here on a motion to quash a number of subpoenas issued in case number 2019-0046 PC. I will start responding to a couple of legal arguments, and then I have a presentation to provide factual background that I actually, presentation to provide factual background to explain how everything subpoenaed is relevant. I would start by refuting the notion that we opened sua sponte our own investigation into the New Georgia Project and the Action Fund. As you'll see in the presentation, evidence regarding New Georgia was actually discovered pursuant to a third-party complaint, known as the Wingo complaint, which alleged third-party interaction with the Abrams campaign and independent committees. And in investigating that case, we were led to evidence that led to this complaint. The argument was made regarding NAACP v. Patterson. I'll be honest, I haven't read that since law school, but my recollection is that was a case in the late 50s that required membership rolls and involved acts of violence and death threats. And that the membership rolls, the Supreme Court said, were not necessary to turn over due to the safety of those parties involved who were members of the NAACP. In Patterson, however, they articulated a standard that you had to, as the party seeking to quash the membership rolls, show a number of things, including, and again, I haven't read this, but something to the effect of imminent harm, danger. You couldn't just say it'll quell speech. There had to be demonstrable evidence that would lead to that. In this case, we're simply seeking bank records of donors. And I think that's very different. And I would point the commission to a couple of cases. Hickey v. RREF BB SBL Acquisitions, 336 Georgia Appeals 411. And that is a Georgia Court of Appeals decision from 2016, which said in the context of civil dispute, a person has no reasonable expectation of privacy when it comes to banking records at a financial institution. It held that they are instruments of commercial trade, which must be necessarily exposed to numerous persons in the ordinary course of business. And in Hickey, it cited the Hatcher v. State, 314 Georgia Appeals, 836, which also held that you have no reasonable expectation of privacy in financial information voluntarily conveyed to an institution. And I think, and I'll come back to that, but that's what we're talking about the item subpoenaed. We're subpoenaing bank records, which Georgia law has held is not protected. We're subpoenaing campaign literature, which the respondent was actively giving out. We're subpoenaing documents that there's no proprietary or, privacy nature that can be reasonably expected. Before I start the presentation, as I said, I put this together to provide background and context into why the items have been subpoenaed. In particular, I would like the Commission to take note of a number of relevant pieces of evidence we will look at. These include IRS documents, Secretary of State documents from Georgia and Delaware, UPS mailing documents, evidence on social media of get out the vote efforts, of electioneering, of direct fundraising, which does not fall into the category of a vendor in any circumstance, of express advocacy by the respondent, as well as, I believe, a text message regarding money. So the parties involved relative to the subpoena, there are 6 that are pertinent, I believe. Ms. Abrams was a candidate for governor. Third Sector Development was the longtime corporation of which Ms. Abrams founded in 1998. Through the end of the 2018 gubernatorial election, she served as the CEO, president, registered agent, and founder. And she remained in those roles through 2018. New Georgia Project and New Georgia Project Action Fund were organizations founded by Ms. Abrams herself as a division of Third Sector Development, her private company, in roughly 2013. For several years, it was openly a division and a wing of her corporation. It was only until about a month before she announced her bid for governor that allegedly New Georgia Project and Third Sector Development split. Ms. MC Ufot was and what we'll show is that she was the executive director of both Ms. Abrams' private company, and would go on to simultaneously serve as the executive director of New Georgia Project and New Georgia Project Action Fund, which developed from voting rights groups into the election and became an express advocacy electioneering organization. Deneen Hodge was the Director of Operations and Finance for both Ms. Abrams Corporation, Third Sector, and like Ms. Ufot, she would go on to simultaneously serve as the Director of Operations and Finance, also for the Unregistered Independent Committee. Finally, Darrell Lindenbaum served as General Counsel to Abrams for Governor's campaign, and would simultaneously go on to serve as the authorized attorney and incorporator of New Georgia Project and New Georgia Project Action Fund during the course of the campaign. I talked about the procedural history a little already. This investigation arose out of an August 1st, 2018 sworn complaint from Charles Wingo, which alleged that the Abrams campaign had violated maximum contribution limits when it coordinated with an independent committee, commonly known as a super PAC. Investigations into independent committees that made contributions then led to the evidence that Power PAC was registered as an IC, making expenditures into the gubernatorial race. What we found from PowerPack's disclosures is that it contributed between May and November of 2018 nearly $700,000 to New Georgia Project Action Fund. That was immediately concerning because it was well known that New Georgia Project had been founded by the candidate herself. Neither New Georgia Project nor the Action Fund have ever registered with the Commission as an independent committee. And the discovery that New Georgia Project, a corporation that was founded by the candidate being involved in electioneering and direct advocacy, raised concerns of coordination. So we're going to go through some documents right here. Here we have Secretary of State documents from Georgia in 2016 for third sector development, the domestic nonprofit that Ms. Abrams has been the longtime CEO, president, and founder of. We look here at April 2017, the renewal with the Georgia Secretary of State. Ms. Abrams is again listed as the CEO, authorized signer, and registered agent of third sector development. In 2018, we see Deneen Hodge, and that's the name we'll come back to, who is now the authorized signer for Ms. Abrams' personal company. And at all times during this time period, the principal address for third sector development was 165 Portland Avenue, Suite A231. Finally, we have Secretary of State documents from 2015. And the highlighted box just shows that third sector development at that time was at the same location on Portland Street. Here we have literature from New Georgia Project. Talks about in 2015 their efforts, but on the third page, it mentions that they are a program of third sector development and that all money to be paid to New Georgia would be written to third sector development. So I'm showing you this to show the intricate ties between Ms. Abrams' company and New Georgia Project, which would go on to engage in electioneering and direct advocacy. I'm going to fly through these. These are a couple of AJC articles that show Ms. Abrams acknowledged she had founded New Georgia. She was paid as the part-time chief executive of New Georgia in 2014. New Georgia's own website recognizes that they are a division of Ms. Abrams' personal company in 2014. More of that. Once staff, and again, this predates my tenure as executive secretary, but at that time, once staff discovered Ms. Abrams' corporation was involved potentially in direct advocacy, they went out and they started investigating social media accounts. And they further found, and we'll go through some of these in a moment, that there was evidence New Georgia Project was engaged in direct advocacy in both the 2018 and 2019 election cycles. These are copies of the subpoenas which you all have. They seek bank records, they seek campaign literature to include handout leaflets, etc., invoices for expenditures, any and all documents, written or electronic, pertaining to any insurance policy held by New Georgia Project Action Fund, incorporation documents, registration documents, and P.O. Box documents. Some of these have become moot because we obtained them from other sources. Relevant law, and this is a point I want to emphasize, the argument was made we don't have jurisdiction to subpoena these items. I point you to 2156, which says the Commission has the ability to issue subpoenas to compel any person to appear, give sworn testimony, or produce documentary or other evidence. So clearly these items fall within our jurisdiction if they relate and are relevant to potential electioneering. As Mr. Lane discussed previously, the motion to quash standard is if it is unreasonable and oppressive. We have Gregg v. State, which says the party serving the subpoena has the initial burden to show why the documents are relevant, and that is why, in this case, I'm going to be providing you evidence that suggests all of these are relevant to coordination. Here we just have the requirements of independent committees to regularly file reports detailing what they're doing if they're involved in electioneering activity, similar with ballot committees. And now we get to social media. Here we see Ms. Ufot is identified as the Executive Director of New Georgia Project Action Fund. Here we see New Georgia Project Action Fund with a donation link where they're raising money outside the scope of any contract. They're raising money on their own accord. And we see canvassing with members, and we'll see this later up close, holding ballots for the slate, the Democratic ticket, advocating for the election of the Democratic ticket.
Mr. Meyer, how do you, go back to the last slide. How do you tell that New Georgia Action Fund is raising money without any, tied to any contract events? Via what we're looking at?
Well, the money they raised from the contracts, and I know you have the power, I've had that contract for about 6 months. There were transactions where PowerPack would send them money. This is them raising money of their own accord. That goes outside the scope of what PowerPack agreed to do, which is pay them X amount of money to do Y activities. So when they're raising money of their own accord, they're not bound by any contract. It's not coming from the committee or a vendee. They can't possibly be acting as a vendor when they're raising money from individuals out there in the community.
So New Georgia Action Fund, under its statement of work, and I candidly haven't been able to read the whole thing, but under its statement of work, wouldn't have ever sent money to PowerPack that it raised on its own?
No. PowerPack in one contract agreed to provide $100,000 in the general election of May for canvassing for Stacey Abrams, and they listed specific counties. That was the contract. There was nothing about sending money back to PowerPack. More canvassing, get out the vote. Here we have New Georgia Project Action Fund hiring, canvassers. Here we have pictures of campaign literature with the entire Democratic slate ticket. And I point this out because in both of PowerPack's contracts in May and October of 2018, the contract was for electioneering efforts to get Stacey Abrams specifically elected. They never mentioned John Barrow. They never mentioned Wendy Miller. They never mentioned Charlie Bailey. They never mentioned anyone outside of Ms. Abrams. So these electioneering activities where they are attempting to expressly advocate for people to vote for John Barrow, which we'll see in a minute, or Charlie Bailey, Wendy Miller, that can't fall within the scope of their vendor contract. They are operating then as their own independent committee. Here we see a closer picture of the slate ticket. I believe this is in September of 2018. We also see the CrowdPack campaign to raise money. And we see a close-up, a partial close-up of campaign literature for the Democratic slate ticket. And this appears to be some videos that were put together. Candidly, I don't know if they made those themselves or if they lifted them from somewhere, but it definitely has the implication of possibly being expenditures they paid to have created. This shows that they're hiring volunteers and that they have field offices throughout the state. I include this because in the PowerPack contract, as you'll see in front of you, it lists a number of counties. It is it's entirely focused in North and South Metro Atlanta. There's no emphasis or mention in those contracts of being down in Albany or canvassing in Dawson, which would indicate they've opened their own field offices to conduct electioneering activity outside the scope of the contract. Here we have a May of 2018 canvassing script wherein New Georgia is canvassing and using express advocacy vote for leaders like Stacey Abrams. And here we have in 2018 in November, this is another example of express advocacy. And this is another example where they go outside of any scope. They could argue a vendor contract with Power Pack because they're also advocating to vote for John Barrow. I'll fly through this quick. This is going to be a bunch of photos of them voting and expressly advocating for the Gwinnett ballot referendum. Vote yes to MARTA, vote yes for transportation, transportation for Gwinnett, things like that.
I've got another question.
Sure.
Where's New Project Georgia Inc.?
I'm about to get to that.
Okay.
I'm just going to move through these. All right, so we're going to get into New Georgia Project Inc., and we'll get into New Georgia Project and the parties involved that are particularly important in this case. About a month before Ms. Abrams announced she was seeking a gubernatorial bid in early May of 2017, New Georgia Project, which had been a division of her company, focused on signing people up to vote, separated. And you see here they registered, they incorporated in Georgia in May of 17, but they incorporated in Delaware in April. Here we've highlighted the address, the principal office address for New Georgia Project Inc. is the exact same address as Third Sector Development. The executive director is Ms. Nisi Ufat, who we'll show in a minute was the executive director of Third Sector Development as well. And the authorized signer of New Georgia Project Inc. is Darrell Lindenbaum, who simultaneously served as general counsel to the Abrams for Georgia campaign. This is Third Sector Development from the same time period, a few months later, renewing their application with the Secretary of State's office, remaining at 165 Portland Street. Ms. Abrams remaining the registered agent and CEO of the corporation, and Deneen Hodge, who we'll cover in a minute, served as Director of Operations and Finance for both Ms. Abrams Corporation and the Super PAC, was the registered signer in January 2018 with the Secretary of State for Third Sector. Here again is Ms. Lindenbaum as the authorized signature, and we'll show in a minute the authorized attorney for New Georgia Project Inc., and also from her bio, and we'll corroborate this in a moment, that she was GC to the AFG campaign. And here are payments from the Abrams for Georgia campaign to Ms. Lindenbaum as general counsel and to her law firm Sandler Reed during the 2018 cycle. Now these are documents from the Delaware Secretary of State. And this is for New Georgia Project Inc. that Darrell Lindenbaum incorporated the Inc. in 2017, April 7th. And here we have from 2018, when they re-registered in Delaware, Ms. Lindenbaum as the authorized attorney for the Super PAC of the IC was the one who re-registered them with Delaware. And next to that in 2019, the Director of Operations and Finance, Deneen Hodge. Now this is Secretary of State documents in Delaware regarding the Action Fund. And you'll see here in April of 2017, Ms. Lindenbaum again is the incorporator. And again is the authorized attorney when they renew it up again in 2018. So what we see is throughout 2017 and 2018 in the gubernatorial cycle, she served as general counsel of the campaign while simultaneously representing the independent committee or the unregistered Super PAC as their lawyer of record. Now we'll move on to Ms. Ufat. Ms. Nisi Ufat here in May of 2017 is the registered agent and, as we saw, the executive director of New Georgia Project Inc. Now it's important to note, and we'll get to this in a moment, the New Georgia Project Action Fund never incorporated in Georgia. And in fact, I don't know if they're in good standing in Delaware because they never re-registered at the beginning of 2019. And as we'll detail in a moment, there's no real clear distinction between the Inc. and the Action Fund, where the line of one ends and the other begins. We go to IRS documents. The 2015 Form 990 tax returns from Third Sector Development. And it's important to note they are still at that 165 Portland Street address. The signature of the officer who submitted the tax returns in April of 2016 is Nisi Ufot as the Executive Director of Third Sector Development. And then at the latest available tax returns for Ms. Abrams' personal corporation, this was filed, and this is important to note, in January of 2019. This year, after the gubernatorial election is ended, Ms. Ufot files tax returns for Third Sector Development, where she still concedes she is Executive Director of the candidate's company, while simultaneously running the super PAC. One other thing I want to point out on the left side at the very bottom, it says briefly describe the organization's passion or most significant activities. And in January of 2019, Ms. Ufot, who serves as the Executive Director for both the super PAC and the candidate's business, writes in about New Georgia Project as if they're still one of their own for the 2017 year, despite the fact that New Georgia allegedly separated in early 2017.
I guess going back to my earlier question, what's being alleged that New Georgia Project actually did? Matt, we're seeing a lot of allegations on social media about what the Action Fund did. What are the allegations about what the New Georgia Project did?
So we issued subpoenas back in April to New Georgia Project and the Action Fund, the Inc. and the Action Fund. We were told by the Action Fund they had no salaried employees. But we also looked at the contract with PowerPack, which PowerPack states you're not an employee of ours, you're a vendor of ours, your staff is your staff. So the question becomes, who's paying New Georgia Project Action Fund staff, if not New Georgia Project, Inc.? And when we got the payroll records from the Inc., it included Ms. Ufot, it included Deneen Hodge, it included a number of individuals we know to be associated with the Action Fund, with the Inc. Basically, it appears the Inc. is paying for the C4, because if not them, no one is. To answer your question, what is being alleged is that electioneering activity occurred outside the scope of any vendor contract by the Inc., by the Action Fund, by some combination of both, and that they didn't register as an independent committee during the process. They didn't disclose their expenditures and their contributions. They didn't disclose what they were doing with their money.
So, under the Campaign Finance Act, can you be liable for, I mean, or would you, I just rather, if you just funded, in your example, New Georgia Project would be funding New Georgia Project Action Fund. Is that something that you would have to register for if you were New Georgia Project?
Yes, and I'm about to show you why, which is that the executive director for both the Inc. and the Action Fund are the same person. The director of finances for both are the same person. The board of directors are the same person. The office address is the same address. There's no distinction between the two. I understand there's a legal distinction between the C4 and the C3. And if the C3 was paying for the C4, maybe you have tax issues there. But ultimately, they're one and the same based on all accounts and the payroll records that we have at this time.
And so it seems it's a lack of respect for a corporate formality issue. The alter ego doctrine, which is effectively, even though they're two separate entities, if you're in effect operating out of the same, they don't have distinct legal separation.
Correct.
Okay.
So here, we get to UPS documents, which we received from UPS. In April of 2015, Nisi Ufot registered or went into a rental agreement for a PO box to accept communications and ultimately money. And she signed up as the, I guess, agent to accept it for both Third Sector Development and New Georgia Project. And that was fine at the time, because New Georgia Project was a division of Third Sector. They were not engaged in any remotely electioneering activity. But in 2017, and the dates are important, on April 13th of 2017, exactly 6 days after New Georgia Project allegedly divorces itself from the candidate's company, she renews the lease on the mailbox to keep accepting mail and money for presumably both organizations. And she renews in 2018, in 2019. And here we have a text message from PowerPack to Ms. Ufot talking about sending them $500,000 to use for electioneering activity. Now, this is $500 they used. Remember, the contract was to work with groups to get Ms. Abrams elected. This is where we have canvassing and phone banking where they're trying to get Mr. Barrow elected, where they're trying to get the slate ticket elected, where they're clearly exceeding the scope and are not protected by the vendor-committee relationship. And when asked where to send the $500,000, Ms. Ufot, as the ED for New Georgia Project, gave the same address that she accepted mail for the candidate's personal business.
And how did you get that text message?
PowerPack provided it. Now, I want to reiterate a couple things. We're here for a motion to quash. We're not here to prove to the standard of probable cause today, even though I think the evidence certainly could argue that. This does not represent the full extent or weight of the evidence we've uncovered thus far. What I am talking about today is limited in scope to what is germane in the subpoena and what I'm asking the commission to deny motion to quash and order them to turn over within 10 business days. Most of this evidence comes from publicly available means. Doesn't include items that New Georgia Project and or the Action Fund have refused to turn over. Does not include evidence the Abrams for Georgia campaign has refused to turn over. Does not involve evidence the candidate's personal business is refusing to turn over pursuant to subpoenas. I think the bank records showing deposits and wire transfers, sources of revenue, which were then used to influence multiple elections in 2018 and 2019, to determine, A, the depth of the fundraising. Because I will concede that while they are posting links to raise money, we have no idea how much, if any, they raised. Because they didn't register, they didn't provide records, and they're not turning over their bank records. They asked to limit the scope of the banking records, or for us to be more specific, but my response is, how can I be if I don't know what you're doing? Insurance records, we have information and belief. Maybe it's true, maybe it's not, but I think it certainly bears investigating. But we have information and belief that Third Sector Development, the candidate's private company, and New Georgia Project's employees were all on the same insurance umbrella coverage together, which would certainly support and corroborate that they were continuing to operate as one and the same even after they incorporated. Some registration and incorporation documents which we've already received, and campaign literature material to their electioneering activity in 2018 and 2019. Finally, the legal standard for subpoenas is it unreasonable or oppressive? And I think I've shown everything subpoenaed that directly relates to evidence we uncovered during the investigation. They should be required to turn it over and comply with the subpoenas. They engaged in electioneering activity. They engaged in express advocacy. They did so out of any arguable contractual scope. And the commission has a responsibility to determine to what extent they improperly tried to influence the 2018 and 2019 elections.
All right, so what, Ms. Branch provided the definition for probable cause. What is your definition?
Well, my position is actually consistent with what the commission ruled on in the last case, which is that when we are investigating based on something that is enumerated, we can file a complaint. I'm not proving, I think we probably agree on the definition of probable cause. My position is we're not right for a probable cause hearing. I do believe it's a reasonable belief that a violation of the law has occurred, but I haven't asked the commission to define probable cause yet because we are simply at the complaint stage and still the investigation stage based on an investigation that arose out of a third-party complaint.
But don't you have to have probable cause to initiate an investigation?
Well, the investigation was initiated based off the Wingo third-party complaint. We didn't initiate an investigation in New Georgia Project. The investigation into Wingo led to PowerPack with the independent committees registered, and that led to where we are today.
So your position is this was not an investigation commenced independently by the commission. This was an investigation commenced in response to a third-party verified complaint, and therefore we don't have to have probable cause.
Correct, and quite candidly, I don't know that we would have ever stumbled across this but for that Wingo complaint.
Okay. And was both of the new Georgia Project entities served with that complaint?
They were,
Okay.
and they're both represented by Ms. Branch.
Go ahead, Commissioner.
A couple of two-part questions, and I may need help from the Attorney General's office on this, I probably should know. When you collect documents in the course of an investigation, are those subject to the Open Records Act just by virtue of you collecting them in the investigation?
No, that's a good question. I'd like to clarify a point that I think was probably misstated. During the active investigation, the only document subject to the Open Records Act is the complaint and any response. Secondly, bank records are actually very limited, even after the case. Like, those get heavily redacted. So even if they turn bank records over, we have a full investigation, whatever happens, happens, the case ends, those bank records just don't go out in full through the Open Records Act. I would also argue, and I think this may be where you're going, but there's no Georgia case law that says that there is a privacy interest in electioneering activities. I addressed the Patterson case, but sorry, you had a two-part question.
Well, no, you're getting there, but the second specific question I had is that, as you mentioned, once the case is over, certain documents, maybe bank records, are subject to the Open Records Act. Are names redacted on the checks?
I don't believe so. And the response I would have to that is, I understand the concern, but that's the deal you make when you try and influence elections. If you're going to engage in electioneering activity, certain records are subject to subpoena and they're subject to investigation. And I really don't think we've exceeded any scope of what we're asking for.
Well, my little, I might need some IT.
Just on that
help.
specific note, Commissioner Watts, the Open Records Act does specify with respect to banking documents what has to be redacted before we actually submit that. The commission would have to abide by those redactions before information is released. And it's specifically listed in the Open Records Act. I don't have it in front of me, but there are specifically listed items that have to be redacted.
Do you know if that's the floor of what has to be redacted? Can more be redacted if the commission so decides?
I do believe it is the floor. I'm not sure that the commission can redact more than what the Open Records Act requires to be redacted. So it might be the floor. But the requirements are outlined in the Open Records Act.
All right.
So I would just say in summation, I think we've shown certainly, and I don't take final positions on cases until I review all the evidence. I've seen enough investigations go one way or the other you didn't expect. But I think at this stage, certainly we've shown that there is evidence present that the candidate was the CEO and president of her own company, that she founded a group that ended up going into electioneering activity, that her executive board members for her personal company continued to run both the company and the super PAC, that the general counsel was involved in both operations, director of finance and operations, that they continue to operate from the same address, the same locked PO box where money was sent. Ostensibly, it appears that it could have just been continuing to operate in New Georgia when it transitioned into electioneering activity. And that's why I think everything we subpoenaed is certainly relevant. It's certainly fair. It's certainly not unreasonable to look at these things and determine whether or not violation of campaign finance law occurred. And I would ask the commission to deny the motion to quash on those grounds.
So, and tell us simply what your two allegations are of violation of that.
So currently our allegations are that they did engage in electioneering activity, they did engage in express advocacy, and they failed to register as an IC, and they failed to disclose reports and expenditures. What we have not yet alleged, because I'm genuine when I say this, I'm not taking a position until I look at all the evidence. What we have not yet taken the step to allege is whether they were one and the same with the candidate's company. If they were one and the same with the candidate's company, that's coordination per se, and then every dollar they spent would be exceeding contribution limits past the $28,000, whatever it was. And I don't care if that's a vendor or it's an IC themselves. If the actors doing express advocacy were one and the same with a candidate's company, that's coordination per se. And so that is a potential allegation, but we're not at the point where we're going to make that yet.
All right. That conclude your presentation?
Yes, sir.
Thank you. Ms. Branch?
I'd first like to correct a couple of statements that were made by Mr. Amati. The first is that we, New Georgia Project, neither New Georgia Project nor New Georgia Project Action Fund were named as respondents in the Wingo complaint. In fact, if you look at the Wingo complaint, they are never mentioned, neither organization. We were never served with the Wingo complaint. And this matter that was initiated by the commission is not related to coordination at all. It is solely, the two allegations are registration and reporting as either a campaign committee or an independent committee. Mr. Amati stated that the commission did not initiate this investigation on its own accord. But if you look at the complaint that New Georgia Project and New Georgia Project Action Fund received, the cover letter states, "Dear Ms. Upat, I'm writing to notify you that the Georgia Government Transparency and Campaign Finance Commission has filed a complaint alleging that you have violated the act. This arose after a review of campaign activities." So this was not related to the Wingo complaint. This was separately initiated by the commission according to its own letter and its own complaint. I think the commission has repeatedly, or Mr. Amati has repeatedly tried to use the Wingo complaint as the backdoor to essentially require these organizations to open their books. This matter is not related to coordination, nor is it related to the Wingo complaint. New Georgia Project and New Georgia Project Action Fund were not named in that complaint at all. So the commission is required to have probable cause to initiate the investigation that it has initiated related to registration and reporting. And again, it has not shown that.
So how do you explain, going back to that, with all the data that we've just been shown, that we've got, the same address, the same general counsel operating in both these New Georgia Project, New Georgia Project Action Fund, all the similarities between the two. How is there not probable cause with potential coordination? And also with the social media stuff we just saw, which indicates that they are in some way influencing elections. How does that not meet the standard in your opinion?
So I would first respond by saying that this complaint, the complaint that we have been given, which is required to be given to us to give us notice of probable cause, does not allege coordination. So the presentation related to coordination, we've not been given notice that the commission has probable cause to initiate an investigation into coordination between New Georgia Project New Georgia Project and New Georgia Project Action Fund and the Abrams campaign. The commission has not investigated or initiated an investigation and given us notice of that. So that's the first piece. The second piece is that every social media post that was shown during the presentation, which I was never given a copy of, but it appears the commissioners all have hard copies of, are all related to New Georgia Project Action Fund, which is a 501c4 organization and under IRS tax rules is permitted to engage in occasional political activity. Moreover, the fact that the C3 and the C4 are affiliated organizations is unsurprising. This is a common setup in campaign finance matters and in tax rules, and it's completely permissible under IRS rules and under Supreme Court precedent. The Supreme Court, in a case called Reagan versus Taxation with Representation, noted that a 501c3 and a 501c4 organization can be affiliated, and this is legal under IRS rules. The IRS has said that a C3 and a C4 can share employees, they can share office space, they can share equipment. And that doesn't mean that the activities of the C4 are automatically attributable to the C3. The organizations can engage in cost sharing, which is exactly what the organization
I understand, but this is probable cause. I mean, I understand all that, and we need to make sure that she gets a copy of this. And we also, I think we need to see the complaint. Do you guys agree that there was an allegation in the complaint about coordination?
No, we have not,
Okay.
we have not made that decision because until we review all the evidence and the withholding, I don't feel comfortable making a final decision on it.
I think that's a separate question. Coordination between is it what you're saying, New Georgia Project and New Georgia Project Action Fund? Or are you saying the third party?
I don't know what the allegation is, because we have not been given notice of it. So the commission is required to establish probable cause to initiate an investigation. This matter is, there's no allegation of coordination in this complaint. It is solely related to registration and reporting of the C3 and the C4 as campaign committees and as independent committees. So the presentation related to coordination between the C3 and the C4 and any other organization is irrelevant to this matter.
But on that point, you even said that the C4 could, I don't think you disagree, did some political activity. Is that not true?
The C4 did not engage in its own political activity with respect to the 2018 and 2019
Even
elections.
when some of the posts we saw said that go vote for transportation or vote for Stacey Abrams, or you don't believe that is advocating?
Well, under Georgia law, I don't think that social media posts constitute expenditures. There's nothing in the Georgia Campaign Finance Code that states that a free social media post on Twitter or any other social media platform is an expenditure under the
And
act.
that's what you're saying, is that they were free. I mean, that whoever was posting it wasn't an employee, wasn't working, that the organization, the C4, did not spend any money to advocate election or defeat of anybody. Is that your position?
The C4 was hired as a vendor by Power Pack Georgia and by Working Families Party Georgia. So with respect to the agreements with Power Pack Georgia, those were related to canvassing on behalf of Stacey Abrams.
But I was going back to your point that you said that the C4 could do political activity. And I don't think we're saying that, or the staff is saying that they can't do it. They're just saying that they need to be registered. So wouldn't that give probable cause? If you even said that it's proper for C4 to do it, the staff is saying they need to see how much was done because it was never registered.
Right, and I don't think that there's probable cause because I don't think that there is evidence to support that the C4 was engaged in its own political activity. It was paid by Power Pack with respect to canvassing related to Stacey Abrams. It was paid by Working Families Party of Georgia with respect to other candidates in the 2018 election. That was the slate card that you saw. Again, they were acting as a vendor there.
And transportation.
With respect to the transportation issue, I would argue, one, there's no probable cause. Two, the definition of campaign committee is unconstitutional. It was not their primary purpose to engage in activity related to the ballot measure. And I would point out again, there were no social media posts that were brought up that related to the C3. The fact that the C3 and the C4 are affiliated organizations does not mean that any activity that was alleged to have been engaged in by the C4 is attributable to the C3. So with respect to the subpoena that was issued to the C3, that should be quashed. The commission simply does not have probable cause with respect to the C3.
I guess that's where I'm you're talking about the ultimate finding here, and not the subpoena to determine whether in fact the coordination occurred. So I mean, I understand there's a line that we're going to come back here, whether or not the subpoena is quashed or not. We're going to come back here at some point, probably, and have another hearing, and in which case we'll collectively decide whether there was coordination or whatever needs to be decided based on the complaint. But I mean, unless you're saying that there's absolutely no basis in the complaint whatsoever, or allegation whatsoever, that New Georgia Project, and I'm just focused on those two right now because Mr. Lundy said that the other entity's not in the picture right now. So unless you're saying that there's absolutely no allegation that New Georgia Project did anything or coordinated with New Georgia Project Action Fund, which I think did some political advocacy, then I mean, if that's what you're stating, that there's no allegation whatsoever about New Georgia Project, Inc., then I think we need to flesh that out.
I don't think there is an allegation about New Georgia Project Inc., the C3. If you look at paragraph 15 of the complaint, it states in the last line,
I'm sorry, can you just read it to us?
sure, just the last line of paragraph 15 is the only factual allegation with respect to either organization. And it states specifically, respondents made expenditures to canvass neighborhoods throughout Georgia. And then it cites to several of the social media posts, many of which I haven't seen, but they were shown. And those are all social media posts made by the C4. If the C3 and the C4, yes, they're affiliated organizations. We don't deny that, but that is completely legal. And just the fact that they're affiliated doesn't mean
So what
that.
your position is, because there's not probable cause as to New Georgia Project, a subpoena can't be issued as to that?
Yes.
Well, what about the subpoena? There's been a number of subpoenas that are issued to entities that you don't have probable cause to believe they violated the act, right? The issue is whether there's probable cause to believe a violation occurred is the standard to commence an investigation. So if the commission found there was probable cause as to New Georgia Project Action Fund, the investigation can be commenced. At that point, additional subpoenas could be issued to move the investigation forward. Is that right?
I think that's correct. But I would submit that the complaint here names both respondents and both the C3 and the C4, and the subpoenas are issued to the C3 and the C4. So there isn't here, both organizations have been named as respondents.
Yeah, but there's not a pending motion to dismiss. The standards seem to be if you're moving to dismiss New Georgia Project, then maybe that's a viable assessment for the commissioners to make. But if we're just determining whether there's probable cause to believe a violation has occurred, thereby justifying an investigation, if that's found that it's a New Georgia Project, then additional subpoenas could be issued, which also could be issued New Georgia Project. That's my thoughts on this. But Secretary Marty?
And this will be the last thing I say. I just want to clarify. I think we need to distinguish the two issues better, and I think Commissioner Watts touched on it. The social media posts, talk about the C3 paying for the C4. This is a motion to quash. It's about the relevance of the item subpoenaed. It's not about proving coordination at this stage or not. I showed all that to explain why everything in the subpoena was relevant and why it was related to the investigation. The other thing I would say is that, even if someone is not a party to a suit, we subpoena banks all the time. So I think they're arguing a motion to quash the 501c3, which is really more of a motion to dismiss, which is not right for litigation yet. That's just what I want to
Is that, just out of curiosity, are you intending on filing a motion to dismiss?
Yes. I would still submit to the commission that you can't use the allegations, whatever they may be, against New Georgia Project Action Fund to subpoena the C3 because there's no allegation of coordination here. There's no allegation of coordination in this complaint. So the C3, you need to have probable cause or at least some reasonable belief that the C3 was required to register and report as a campaign or independent committee. This isn't about coordination. This is related to registration and reporting. And you can't use, any allegations of coordination between the two to subpoena the C3.
But to your point earlier, you stated that it's common practice for a C3 and C4 to be affiliated.
That's correct, but they're still separate organizations. As Mr. Amati showed earlier, they're separately incorporated. They can share office space and equipment as long as there's cost sharing between the two, and that's what's happened here. But that doesn't, they're still separate organizations that have separate mission statements that engage in different activities, and you can't use allegations of coordination, which have not been properly alleged here, to backdoor a subpoena to the C3.
It just feels to me as if we're talking about a motion to dismiss and a potential amended complaint based on what's alleged versus even if the staff has alleged that New Georgia Project Action Fund has done something wrong under the act, and then they're saying New Georgia Project Inc. and New Georgia Project Action Fund are one and the same. Not because of IRS standards, but because of potentially the coordination or the sharing of funds or what have you, and how the money is flowing through there. I'm not saying how even if that's the case, putting aside whether the motion to dismiss will be filed, an amended complaint will be submitted or what have you, that seems to be right for a subpoena. The New Georgia Project Inc. could be subpoenaed based on those allegations alone.
Well, I would submit that if that is the case, that the subpoena is still overbroad. With respect to the First Amendment objections, there's significant First Amendment case law that states that organizations that are engaged in this type of civic and political advocacy are protected by the First Amendment from having to turn over all of their documents and the inner workings of their organizations unless there is a heightened standard that has been met. And I would point the commissioners to Federal Election Commission versus LaRoche campaign. That's 817 F 2nd 233. It's a Second Circuit case where the Second Circuit stated that where the investigation and the subpoena tread in an area rife with First Amendment associational concerns, an administrative agency is not automatically entitled to obtain all material that may relate in some way to a proper investigation. If you look at Perry versus Schwarzenegger, which is a Ninth Circuit case, it states that once the recipient of a discovery request or a subpoena shows arguable First Amendment infringement, the government is required to demonstrate a higher showing that the information sought is rationally related to a compelling governmental interest and is the least restrictive means of obtaining the desired information. The list goes on. There are cases from the 10th Circuit, from the DC Circuit, most recently the 6th Circuit in Ohio, a Philip Randolph Institute versus LaRoche, recognize that there is a heightened relevance standard when a governmental agency is seeking documents related to the political or advocacy inner workings of an organization. This subpoenas seek the bank records of these organizations. It would require them to disclose donors. They would be subject to the Open Records Act. Mr. Amati has stated that the names would not be redacted.
So let's just keeping the ball moving here. So campaign literature material, do you object to producing that?
We don't object to that, producing that, so long as it is related specifically to the 2018 and 2019 elections.
Okay. Is that what you request, Secretary Amati?
We request from, I think it was May 2017, whenever they incorporated. Yeah, I mean, it's the 2018 cycle. And candidly, I don't know there's going to be a lot there in 2017, but it's the cycle. So we're asking for the 18 and 19 cycles.
Okay.
But the 18 cycle does not start on the date of incorporation of these organizations.
Well, so in principle.
She had already declared her candidacy. I'm sorry.
Well, let's just keep, in principle, campaign literature you're okay producing. Insurance records.
We would object to producing those.
Okay, why?
As outside of the scope of the Commission's jurisdiction. Mr. Amati stated that he was seeking those related to a coordination allegation, and that has not been alleged in the complaint. We have received no notice of probable cause of finding coordination with respect to the Abrams campaign, Third Sector Develop, and the NGP organizations. The Wingo complaint, as I stated before, was not given to us. It also did not name New Georgia Project or New Georgia Project Action Fund. It alleged coordination between the Abrams campaign and other third parties.
Mr. Amati, are you only requesting the insurance records for coordination?
Well, it would also go to cost sharing between the candidate's personal company and the unregistered independent committee.
And so how does that relate to the allegations of the complaint?
So we don't have to allege something to investigate it. I mean, we're allowed to investigate beyond the scope of an existing complaint. And I think I fundamentally disagree, and this has been litigated at the Supreme Court in Georgia repeatedly, we can, if we get a third-party complaint, we're not bound by just the allegations there. If there's anything that relates to those allegations, we can expand the investigation to our job. And so I don't think there's anything inappropriate about
Ms.
it.
Branch, what's your response?
This complaint was initiated by the commission. That's what's stated in the complaint. It is not related to the window complaint at all. It states that.
But the question is, are they limited to the allegations made in the complaint to investigate?
Under the commission rules, the commission is required to provide respondents with notice of probable cause of the basis, or the basis of probable cause for the allegations. We have received no notice of the basis of probable cause with respect to coordination. We have only received notice of probable cause with respect to the allegations related to registration and reporting, and that's under the commission rules 189.2-.04. It states that you are supposed to receive notice of the reasonable basis of initiating the investigation.
And Secretary Monty, do you agree that no notice was provided as to coordination?
We haven't provided notice because we're not alleging it. We don't have to allege something to investigate. And that's the point I keep coming back to.
All right, the registration and corporation documents, do you object to those?
To the extent that they are, the subpoena is broad enough to be seeking any documents related to registration and incorporation, including communications, which we would contend would be subject to the First Amendment privilege. I also, based on Mr. Mahdi's presentation, understand him to be seeking those documents with respect to the coordination allegation. And I think all of the requests in requests 6 through 9 are all related to the coordination allegations, which we have not been given notice of. So I think the same argument applies with respect to requests 6 through 9.
Mr. Chairman, it'd be reckless of me to allege coordination without looking at evidence that either proves or disproves it. That's the point of the subpoena.
All right, well, yeah, go ahead.
Look, I'm very sensitive to the First Amendment issues, which is why I asked the questions I did earlier on the Open Records Act. My presumption is, to the extent that you think that any of these are barred by the Constitution, the first thing you're going to do if we deny the motion to quash, is that when they try to enforce a subpoena, you're going to go to court and say this is unconstitutional. Am I right?
That's correct.
Right. So my position would be, I don't think that we necessarily need to litigate everything in the subpoena. Mr. Ahmadi and counsel from Ms. Abrams has already said that you're not going to agree with it. And so it's going to be a litigated issue. So to that extent, I mean, we might as well rule on the motion as it stands right now.
And it's not a motion to modify.
I think there's are you also seeking to modify?
My understanding is that the commission, Mr. Ahmadi stated earlier that he was not open to modification of the complaint, of the subpoenas. I apologize.
Well, are you seeking permission to do any modification to the breadth of the...
With respect to some of the requests, we would like to seek to modify to the extent that they can be narrowed to alleviate the First Amendment issues and the probable cause issues. I would just submit that this appears to be a fishing expedition. Mr. Ahmadi has essentially admitted that by saying that he's seeking documents related to the coordination allegation, despite the fact that he has no basis to allege that. So he wants these organizations to open their books so that he can fish to see if there's coordination, and would submit that that is not allowed under the commission's rules.
All right. Well, we got to keep moving, and I think both of you guys did a great job. I appreciate you, Ms. Branch, attending today. My thoughts on it are: this is the preliminary stage. It is initial. There's debate as to whether probable cause is needed. Mr. Ahmadi or Secretary Ahmadi and the commission staff represent that it's not needed because there was a complaint that's been filed. Regardless, based upon what I've seen, I do think that there's probable cause to believe there could be a violation of that. I'm sensitive to what Commissioner Watt said, which is it's going to be hard to break down piecemeal. I would love for you guys to get together and try to work out as much as you can, but I understand the dynamics at play here. But with that, I'm going to make a motion to deny the motion to quash. Although I don't think it's entirely necessary, I do believe that there's probable cause to believe that the Campaign Finance Act was violated, and so I will make that motion.
And Mr. Chairman, sorry to interrupt, I know this is a fishing expedition and all, but before y'all vote, I actually would be willing to offer on the fourth point where they seek to protect anything that's attorney-client, I'd be willing to meet on that issue and create a privilege log where only if we disagree do we have to litigate about that. But I think that's something that would be fair to try and work out before litigation.
Well, I think that you guys should definitely do that. So there's a pending motion. If there's a second.
Second.
Okay, we have a motion and we have a second. Any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed? Hearing none, the motion carries. So we will take a recess. How much longer do you think, Commission staff, we've got for the afternoon? 10 minutes is the word of the day. Okay.
It should move pretty quick from here.
Okay, well, we'll do lunch then. We'll do a 30-minute lunch, so a quick lunch. All right, I'm going to recall the meeting to order. The next section, we've got the preliminary hearings, and who's here for the preliminary hearings? Anyone responding here? We got one. What's your name?
Colton Moore.
Colton Moore. All right, anyone else?
Senator David Lucas was here earlier, but I don't see him back yet.
Okay, and that's it. All right, well, given you're here, Mr. Moore, we'll start with you and who on the...
I've spoken with Mr. Moore. There are some issues that we were going to raise in aggravation. He's brought up some points that I think he and I need to sit down and discuss, and that may resolve it to a degree. So I would ask two things. I would ask someone on the commission to remove Mr. Moore's case and move that to a future date, and then to move Senator Rahman's case off of the PC and into the consent.
Okay. Well, I'll make that motion. If I can get a second.
Second.
All right. Motion and second. Any discussion? Hearing none, I call the question. All in favor say aye. Aye. All right. So Rahman is moved to consent, and then Mr. Moore is removed from the agenda.
Yes, sir.
All right. Anyone else here? Okay. Well, staff is... You want to jump in, Mr. Lane, or?
Mr. Chairman, the next one, Mr. Lucas is here, but I don't see him in the room.
We can move this in.
Ms. Romero is now in consent order. Mr. Dukes is now in consent order. Mr. Jones's case will be continued to the March calendar due to conflict by his attorney. Mr. Dexter Sharper is a consent order, and then Ms. Horacina Tate is a continuance to March, so that a new complaint can be drafted to add allegations.
Okay. So the rest of them are preliminaries.
Just give me a second to set up my PowerPoint.
I have a question for Mr. Lane.
Yes, sir.
If you move one from a preliminary hearing to a consent order, is that something that we hear today, or is that a future day?
The consent will hear today.
Even the ones we just moved down?
I moved one on, but I moved one down
Sure.
today.
Yeah, but I thought Mr. Lane just said that several more were consent orders.
this phone is hot today.
All right, Commissioners, you have in front of you the matter of Mark Allen Urbach, it's 2018.
And hold on, is Mr. Urbach here? Okay, go ahead.
It's 2018-0012.
It's down.
Down, okay. All right, and so just background about this case, he was a candidate for the governor's race in November 6, 2018 election cycle. He qualified to run in the Republican primary on March 9, 2018, for the May 22nd, 2018 primary. His declaration of intent was filed on August 11, 2017. He quote-unquote withdrew from the governor's race on May 1st, 2018. And I say quote-unquote just because he withdrew on Facebook. He said he was withdrawing his candidacy on Facebook. So he never filed anything in his campaign. Everything came off the ballot. Like I said, no termination of his campaign has been filed. And he raised just about $4,300 for his total campaign, and 41 of that came from himself. So that's kind of gives you a look into how much money was actually raised by his campaign. This came in as a third-party complaint filed by Mark and Patricia Zeller. Basically, just to boil it down, they did not like Mr. Urbach, and there is some dispute between the legal defense of one of their friends in which Mr. Urbach, out of his personal funds, paid for somebody's legal defense. And I don't think they were happy with that. And it basically boiled down to him at some sort of Republican meeting. They got in an argument, and hence this complaint was filed. So this complaint deals with more of the filing aspects as opposed to the merits of their complaint, because there wasn't any that was defined under the Campaign Finance Act. There was a notice of additional allegations that was issued by us on March 26, 2019 for a failure to file campaign contribution disclosure reports. There was a notice of additional allegations for a failure to file a personal financial disclosure statement. He actually filed that on time, so I have taken that out of the complaint. We're not moving forward on that, so he filed his PFDS on time. There was a prior notice of this hearing before. He obtained counsel, I believe, a couple months back, and went for the hearing and was told to try to go and negotiate it. And prior counsel said he was going to have some hardship documents that dealt with a sort of mental health issue he was going through at the time. To this date, we haven't received that. I got a call from his counsel who said they weren't going to be here. We're going to try to work forward to consent with sort of the mental health stuff coming in, but to this date we haven't received it. We haven't received any documentation of a hardship. So at this point we're moving forward to establish probable cause.
Then why did his counsel not appear today?
I don't think they dispute that there is a probable cause determination that would be made that he didn't file. It was just he hasn't had time to get the documents together, or Mr. Urbach has not given him those documents. And he's from Brunswick. He wasn't going to drive up here just to say he didn't have them. And we've given him, I've emailed with him the past 3 months to try to get those documents, to try to reach a resolution on this, and he hasn't been able to produce them. So we're sort of at the point.
So he's effectively just consenting to probable cause.
Basically, without so much as consenting probable cause, they realize he didn't file, but at this point, we have to go forward with the hearing because we just can't keep putting it on. So here are the two filings that Mr. Urbach has made. The January 31st was late, and that was on February 27th. He actually filed his March 31st one on time. That was within the grace period. So he had to file on January 31st. His campaign was after, it was after January 31st, so he didn't file that one, but April 30th, June 30th, September 30th, October 25th.
That's the new law, not the old law.
Oh, I think he had the March 30th. Yeah. But yes. And so here, he filed March 30th on time. January 31st, he filed late. So there is the filing schedule. So the violations were alleging he didn't file, or he failed to file a timely January 1st, 2018 CCDR, and then he failed to file the June 30th, September 30th, October 25th, and December 31st. So he has yet to terminate his campaign. He was still subject to those filing dates. He was an unsuccessful candidate, so technically he would have to file at the end of this year. But those are the violations that we are alleging that he has violated by not filing those CCDRs. That's based
All
on.
right, Commissioners, any questions?
Is the staff going to say it's a violation for people when they file late, even though we have late fees? Because the first violation was that you violated the law by filing late. Even though we have late fees, are we going to add those as violations as a matter of policy?
As a matter of policy, we'll include those when there are more substantive violations, but we're not going to be filing complaints solely based on a late fee.
All right, any other questions? Anyone want to make a motion?
Well, sorry, I've got one more question. You said that there might be some consent entered into after this.
Yes.
So if we adopt the motion on the preliminary hearing here, you could still modify it
Yes.
based on the consent that you approved.
Yes.
I'll make a motion that we adopt the staff's recommendation for matter 2018-0012, the matter of Mark Allen Herbach.
Second.
Is that the right motion? Or is it just, is it reasonable grounds to believe, or are we adopting?
Grounds to believe that it can't be.
Yeah, I'll just make that amendment. We're moving that there's reasonable grounds to believe that the Campaign Finance Act is violated, and then get a second for that. All right, second motion, all in favor, say aye. Aye. All right, motion carries. And then, do we have anyone come in that was here responding? Either of you guys? No? Mr. Lucas? Okay, yeah, since you're here, come on up. We'll have yours next. Okay, and then what's your name, sir?
Who was that just for?
That was for Urbach, Mark Urbach.
Okay.
Yeah.
Are we able to speak?
Are you the complainant?
One of them.
Oh, absolutely, sure. Come on up. And just state your name for the record for us, sir.
My name is Mark Zeller, and I'm here to, I asked Mr. Kuzak to send me the form because I never kept a whatever. But in gist, there was a woman that her husband has PTSD, he's a military guy, and I'm a military advocate. And the wife was not so good either. And he took money from her, and after he took money from her, then he turned around and, should we say terrorize her? I have to say it on the phone. And I told her, I said, that's just not going to fly. And there's several other people that will testify to this, especially somebody that's a really good friend of this woman in Gainesville. So, long story short is that's what I have to say, and a lot of the things that go on are skosh. My better half over there, she did fill out a form too, but she never got a letter. So.
Well, good. Well, thank you for appearing. We've considered the complaint, and the commission just found reasonable grounds to believe that the act was violated. So we'll be moving forward. I believe they are discussing a potential consent judgment or order to resolve it. But for the time being, it's moving forward for prosecution. But I appreciate you coming out today.
God bless you, sir.
Yeah, thank you. All right, Mr. Lane, whenever you're ready, and then Mr. Luke, you're welcome. Once Mr. Lane is concluded, you'll have an opportunity to present your defense.
Thank you, Mr. Chairman. Commissioners, what you have before you is case number 2019-0041 PC in the matter of Mr. David Lucas. Mr. Lucas is currently the District 26 Senator to the Georgia State Senate, and he was most recently elected to that office in 2018. Mr. Lucas first filed his declaration of intention to accept campaign contributions, which is the form that gives this commission jurisdiction over his actions, on May 16, 2011, and he most recently qualified to stand for re-election on March 5, 2018. Senator Lucas was part of the audit of all Georgia State legislators, and during his audit, commission staff was able to identify that Senator Lucas failed to file his June 30th, 2019 and January 31st, 2019 campaign contribution disclosure reports. That's a violation of 21534C1 for non-election year reports. He also failed to file his December 31st, 2018, October 25th, 2018, and September 30th, 2018 campaign contribution disclosure reports. All three of those are violations of 21534C2A. And we also have alleged that Senator Lucas failed to timely file his June 30th, 2018 campaign contribution disclosure report. So in other words, he was late. He filed that report on July 10th, 2018. That would constitute a violation of section 21534C2A. Additionally, and finally, the commission has alleged that Mr. Lucas impermissibly accepted $500 in campaign contributions from Waste Management Incorporated on January 18th, 2018. The impermissibility in that is it's a violation of 21535A for members of the General Assembly to accept campaign contributions during a legislative session. And the legislative session in calendar year 2018 for the General Assembly began January 8th and concluded on March 29th, 2018. Senator Lucas's records, or his bank records, were subpoenaed by the commission. There's been numerous correspondence between Senator Lucas about the production of those records, and to date we have not received those records. For those reasons, the commission staff respectfully submits that there are reasonable grounds to believe that a violation of the Campaign Finance Act has occurred, and we recommend that this case proceed forward to an administrative prosecution with the Department of Law.
Okay, Mr. Lucas?
Afternoon. It's been a long day. I heard it all. First of all, it's my fault. In June of 2018, I lost my lease. It was in an estate and it was sold to a private concern. During that time, I had to move everything. I moved to Iron Guard, which is a storage facility. I had to go get the paperwork and everything, and I filed. When it came to September, I was running late, and in October I had open heart surgery. So I didn't file the September nor the end of the year, and basically through January of 2019. If you go through open heart surgery, when you get old, you don't recuperate as fast, and so it took me a minute. In August, I received a certified letter from the Transparency, and I ended up having to go into the hospital for diabetes. I was back and forth. I had a operation, stents put in my legs to go to my feet because I had infected toe. I did 6 weeks of PICC infusions and finished with an amputation. I did file, I did send the documents. Now the one where the violation for accepting campaign contributions after we go into session, that was a mistake on my part. I should have had 1/8/2019, and I ended up putting 1/18, the slash on the thing. I've asked the bank to go back and do research and give me the deposit slips for 2019 with the check images on. On my deposit slips, I usually stamp them, take them to the bank, and give them all at one time. So I need to retrieve the documents that will show the date of the check and everything on it. My understanding of the law was that if checks were postmarked and dated prior to going into session, that you could deposit. Anything after that was dated after the date the session began, you could not put them in.
Okay. Well, what's your understanding, Mr. Lane, as far as the backdating and deposit of checks during session?
About 4 years ago, the commission adopted a policy that is the acceptance of the check and receipt by the candidate. That's the effective date that the contributions are received. It's not when it's postmarked, and it's not when the check is presented to the bank. It's when the candidate takes official possession of the check.
Okay. Well, Mr. Lucas, it sounds like, you know, you made a mistake. We all make mistakes. I get it. And it sounds also like maybe there's a hardship opportunity for you guys. Have you guys considered a hardship opportunity given Mr. Lucas had open heart surgery and had a diabetes scare?
I'm afraid this is the first we have been hearing from Mr. Lucas regarding these hardships. The
Okay.
last correspondence we had from him was in October of 2019 regarding not receiving his subpoena, and we resent it to him. And that was the end of our communication. We are always, and I think the commission knows this, under our rules, there's a 30-day period after you find reasonable grounds in which we continue to negotiate and try to resolve cases. We're more than happy to continue trying to resolve the case and consider whatever hardships there may be.
Well, to the commission, I wasn't trying to go out publicly to tell folks I was sick. But, I mean, the records show that I had open heart surgery, and then I ended up having surgery again after receiving the letter from you all on the 30 days where I was served, where I signed that you were asking me to produce the records. And I ended up going back in the hospital and having stent surgery, and then after that didn't work, then I ended up going back again for the amputation.
Okay. What is the fee? What's the total fee?
We have an assessed one.
Okay. Well, what I would propose, Mr. Lucas, would do, because we'll have to find reasonable grounds to believe that the act's been violated, because it has, but you have 30 days to pursue a hardship opportunity. I would encourage you to do that, and I'll tell Mr. Lane to facilitate that opportunity with you to the maximum extent he can. And hopefully it gets worked out. The next time you just pay attention to those deadlines and don't deposit a check during session for a contribution, you won't have to see us again.
Well, listen, the question has always been, and I would say this to you, that I have not paid attention to the current law that you're talking about, but you used to be our understanding that if the checks were received prior to the date of going in session, if the date on the check itself, which a lot of times the checks are mailed to us, and for instance, like myself, I get the mail at the house, I might go through some and put some on the side, and the next day or next week I might go through it trying to clean up, and then you find a check that was sent to you that you didn't pay any attention to. You had to open the mail up, and the check was dated, and the date on it was prior to the session beginning.
I understand. Do you have any authority on that understanding?
Do I have
any legal authority? Because we have to.
No.
Okay.
No, I don't. I just, that it was assumed.
I know. Well, we have to apply the rule. I wish I could just say, you know what, Mr. Lucas said it is. No. We got to apply. Commissioner Watts?
I think even under the commission's policy, Mr. Lane, under that scenario, if you were to receive the mail on, it's a date stamped, whatever, and you receive it on January 7th, and session starts on January 8th, then you deposit it on January 15th, that's still legal, right?
Correct.
Right. So it's not just when the check is dated. I wasn't on the commission at the time, but I would presume the reason is why is because we could be in March 15th in the heat of session, and all of a sudden you get a check dated for January 7th, and that's what we're trying to avoid.
Well, and I understand that. Just like I said, the assumption was that if you got it, the date and the check on the check itself, because usually you get a check with a date on it, and it says you have to deposit within 90 days. So.
Okay, we're going to keep moving. You remember, you get with Mr. Lane, you pursue that hardship, but I'll move that we find reasonable grounds to believe that the act was violated in the matter of David Lucas. And motion and a second, any discussion? Hearing none, all in favor say aye. Aye. All opposed. All right, motion carries. And do we have anybody, so I guess that's it. Everyone else? Okay. All right, let's try to move through these as quickly as we can, given I don't think anyone is here to respond.
Commissioners, this is going to be a matter of Sabrina McKenzie. This is two cases, or two case numbers, 2018-0109 and 2018-0058. They deal with two separate filing violations. Just a little background for this one. Ms. McKenzie was a candidate for State Senate District 41 in the November 6, 2018 election cycle. Her declaration of intent to accept campaign contributions was filed on March 9, 2018. She then qualified to run on March 5th, 2018, to run in the May 22nd, 2018 Democratic primary against incumbent Senator Steve Henson. She was ultimately the unsuccessful candidate in the May 22nd primary, and to this date, no termination of her campaign has been filed with the Commission. There's two complaints here. The first complaint is 2018-0058, which was filed June 19th of 2018 by Ann Rosenthal. That complaint alleged that Ms. McKenzie failed to file her PFDS within 15 days of qualifying. To this date, she hasn't filed PFDS, so she has not filed a PFDS for the year covering 2017 where she ran for office.
Was this one of the ones in the audit? The legislative audit you guys did, it was not?
This is a third-party complaint.
Okay, got it, thanks.
There was a second complaint filed by Ms. Rosenthal in that Ms. McKenzie failed to file a June 30th, 2018 CCDR. The Commission issued an amended complaint against Ms. McKenzie on October 9th of this year. There was a subpoena issued to her for her bank account. She has not responded to that. To this date, she has not responded to the Commission at all. And I'll kind of get into that in a later slide of what's happened. There was also a subpoena issued to Clear Channel Billboards because we became aware that she had bought an advertisement using Clear Channel for a billboard, one of the digital billboards. So we were able to subpoena them and get some information regarding the expenditure made. With that information, we were able to re-amend the complaint on November 7th of this year, and that was with Clear Channel information. She's been served at the address that's on file with the Commission. However, whenever I call or identify myself as a member of the Commission, they hang up on me. There's also been email service of the whole complaint package. She, in her day job, she is a dancing pastor and does some booking engagements. She has a PR firm. I emailed the whole complaint package to the PR firm and her booking agent, and still have not heard anything. Myself and Mr. Morris, the legislative liaison for the Commission, we actually drove out to the campaign address, which is a home in Stone Mountain, and we left 3 packets on the doorstep. And if you actually look inside the home on a sofa inside, it says Sabrina McKenzie, women's activist, and about 4 pillows. So we knew we had the right house. It just seems like even though they were served, nobody wants to answer to this. So she's been properly served, but it's just choosing to ignore basically any authority. The first allegation is a failure to file a CCDR, or failure to file multiple CCDRs in violation of 21534C1 and C2A. As y'all can tell, this is the only filing that she ever made with the Commission. It was for the March 31st CCDR. She filed it on time, but that was the one filing that was ever made during the whole campaign year. So just one filing and that's it. Basically, she had to file, I got the law right on this one, but she had to file March 31st, June 30th, September 30th, October 25th, and December 31st. She filed the DOI after January 31st, so she did not have to file the January 31st CCDR. And here's the one filing that she's made, which was March 31st. And there's the filing schedule, and to this date, she's not filed any of those. And so we've alleged that she's basically not filed 4 reports during the time she's run for office. Now, she also failed to file a personal financial disclosure statement in violation of OCGA 21550A1. Since she qualified to run for this position, she had to file after the 15th day. She just didn't file. She still has not filed to this day. here is our interweb showing she has not filed PFDS to extend. Now this is where the subpoena comes in and some of the information we've developed throughout the investigation. She has made expenditures in her campaign. I'll go over the CCDR that she actually filed. But any expenditure of more than $100 has to be disclosed. That's pretty well settled. There's not a single expenditure listed on that March 31st CCDR. She took in contributions about $3,500, but there's not a single expenditure listed. And so here is her CCDR for that March 31st, 2018 filing. We go through it, and here we have $3,500 in contributions, and expenditures is 0. So there's not even any expenditure portion of this because there was none, but she took it. There's no debt for the campaign, and here's all the contributors in her campaign. It's $3,500 for the total amount that she alleged to take in during this campaign. And we'll see, I think, from the evidence, it's going to show that there was actually a lot more money taken in and expended during this campaign. So we were able to, in that clear channel subpoena, we received the check and the contract for a clear channel outdoor advertisement. It was an outdoor billboard, which said Sabrina McKenzie, State Senate, District 41. And that was on March 30th, 2018. She failed to report that. Upon further information, believe this is from all social media, but we believe that she has made other expenditures for various campaign literature, signs, mailers, etc., without reporting anything. And so we'll get into some of those, and I think Dr. make a common sense leap that it's going to be more than $100 that she should disclose. So here is the Clear Channel contract. You can see her name at the top. It's Sabrina McKenzie Dance, and that's the dancing pastor thing. I think that might be the company, but it's Sabrina McKenzie, her name, executing the contract here on March 30th, 2018. Here's more of the contract, and then there's the check for $4,500 to Clear Channel. So she made that expenditure, even though that's more than the actual contribution she took in. There's the actual billboard that she bought with that money. Now here are the additional expenditures that we were able to just find through social media. These actually came in with the complaint, and these are targeted mailers for people that were in State Senate District 41 that are basically saying Ms. McKenzie's running for State Senate District 41, vote for her. So they're all targeted mailers. There is a sign on her, a sign that is pretty large. Also another sign outside the gas station. And here in her, I guess this was her Twitter, they claim that they had 570 signs and 3 billboards. And so working in campaigns costs money. That costs a lot of money. That costs more than $100 to get that stuff. And this campaign is saying they made expenditures of nothing. So I think it's a fair assumption that there have been expenditures and a large amount of money made that just haven't been disclosed. Here's another targeted mailer that was mailed in Senate District 41. Here's another sign, T-shirts.
I assume none of those, or you looked and saw that none of those billboards and signs or in-kind donations that were under the threshold.
They were not. Here's more signs. There's little flyers, more signs. Here's another mailer. And here is an actual, and to actually rent one of these, I called the company, and to get one of these mobile ads, it's about $800 to $1,000 a day to get that, to actually purchase one of those for the day. So at the least, we're in $800,000 that hasn't been reported. And here is her in U-Haul, and this is the day before the primary, with a huge sign on the U-Haul, so nothing regarding a U-Haul as an in-kind or expenditure has been reported. And so I just ask that the commission find there's reasonable grounds to believe that the Campaign Finance Act has been violated by Ms. McKenzie.
All right, is Ms. McKenzie here? All right, well, I said this at the last meeting, and I'm going to reiterate it. If you're served with a complaint and it's contested, you need to show up. And to me, I think this is an aggravating circumstance where you've attempted multiple times to contact the person, she's refused to communicate back, and she refuses to show up. What Mr. Lucas did, I think, is the admirable way to do it. You come in, you take accountability, you said, I messed up, I'm sorry. You attempt to explain yourself, but in this situation, I think this is an aggravating circumstance. And I think we need to discourage people from just not taking their obligations under the Act seriously, and we need to encourage people to take it seriously and to show up and not just ignore phone calls. So with that, what's your recommendation for, first of all, have you made a determination on how much you're seeking in fees? And as far as this being an aggravating circumstance, what would you recommend for increasing that amount?
Well, before we wanted to make a determination on that, I wanted to see what was actually expended by the campaign and sort of try to proportion that out into a fair and equitable, I guess, resolution. So we haven't come up with a number yet, but given that this is an aggravating circumstance, we've expended time trying to get in touch with her and have gone above and beyond. So it will be high on that.
All right, Secretary Bonnie.
And Mr. Fuller can correct me if I'm wrong, but if the commission finds reasonable grounds to believe a violation has occurred, we move into OSA. At that point, Mr. Fuller can issue subpoenas, and if she ignores those, she can be held in contempt of court, correct?
That is correct. And also, I guess, to the fine amount, when we move forward in OSA, the judge will make the initial determination as to the findings of fact and the amount that the respondent should be penalized. And so even if in any preliminary agreements or consent orders that are given by commission staff to try and resolve these situations, it's always at OSA sort of a fresh start where we get to try the facts of the case as they are, and the court then determines what, if any, violations occurred and what fines are associated with that.
Yeah. So the commissioners have no input.
No. So the OSA judge will institute a fine taken upon recommendation and argument by Mr. Fuller. It then moves back to the commission, and you vote to either adopt the ruling, amend the ruling, or I guess reject the ruling. So you can escalate it, you can move it down. The final decision with the commission.
Okay.
Correct. And just want to make one clarification. After an initial decision is made by OSA, it then comes back before the commission for a final agency decision. There are three options. The commission can either modify that decision, you can affirm it in whole, or if no action is taken by operation of law within 30 days, it becomes final. So those are the three options that you guys have after we finish the OSA procedures.
Got it. All right. Well, I'll move to find reasonable grounds exist that the act is violated.
Thank you.
Motion and second. Any discussion?
Just a quick note on the amended complaint in the binders, under number 12C3, there's a scriber error in 2019, should be 2018 before you move forward.
Okay. All right. Well, make that adjustment, and I'll call the question. All in favor, say aye. Aye. All opposed? Hearing none, carries. So how many more do we got?
4 preloads and then consent orders.
So one of my preliminary hearings is not going to go forward.
Okay. And which one is that?
2017-234, Thomasville citizens. I'm sorry. I'll come back. Oh, no, I had 2017-234.
And that was continued?
Well, I would ask that the commission continue it. I received an email from who was the former attorney of record for the entity, who says now that they've retained new counsel, but did not provide who that is, and so we'd like to reach out to the attorney and get contact with them.
Okay. All right, I don't know if we need to make a motion to that effect or not to continue it. But we can. We'll move to continue. In the matter of Thomasville Citizen for Responsible City Management, I will move to continue that to the next meeting. So I get a second. All right, motion and second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries.
Mr. Chair, one thing, let's just, since we're doing that for this case, I move to continue 2019-35 PC in the matter of Vernon Jones.
You should maybe do a block. How many other ones do we have that's continued? Is that it?
2019-42 PC in the matter of Corsana Tate.
Okay.
I think that's it.
All right. Is there any other ones? No? All right, I'll second that. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Motion carries. And whenever you're ready.
So the first case that I'm going to discuss is the matter of Erica R. Thomas, 2018-56. I think the binder divider, the first page has 2019 case, and we'll counter that on a later page. But all of the rest of the documents are accurate for the 2018 case. And so this is the result of a third-party complaint, and there were a litany of allegations. So what we're bringing before the commission are actually 5. I left the 5th one off, but Ms. Thomas has failed to file CCDRs, failed to file PFDSs, and also untimely filed CCDRs and PFDSs. And there's also an allegation of improper use of campaign funds or expenses that don't appear to be ordinary and necessary. And so just as a brief, we probably covered the statute 2 times today, but here we have the statute for discussion of when these CCDRs from Ms. Thomas should have been filed. And so I have a chart later on in this presentation, but there are non-election year and election year CCDRs that Ms. Thomas did not file. And this is just the statute for that. And there below that you have the statute for the PFDSs that Ms. Thomas did not file or untimely filed. And then here is the statute and a screenshot of the CCDR where Ms. Thomas has an expenditure for $750 at a luxury nail bar and spa. And just on first blush, it does not appear to be an ordinary and necessary expense. Could have been explained by Ms. Thomas, but we did not receive any response to complaints. And so our position is that this is not an ordinary and necessary expense.
What's the purpose saying?
It says district spa night. And so here are just some key dates related to Ms. Thomas and her campaigns. She has been the state representative for District 39 since about 2015. She was elected in 2014, sworn in January 2015, and subsequently re-elected in 2016 and 18. She qualified on March 8, 2016, and her PFDS was due on March 23rd, and then in the next election year, she qualified on March 7th, and the PFDS was due on March 22nd, and this is also in a chart later on in the presentation. And so some procedural history, just to cover those bases. As I stated earlier, this is a third-party complaint filed by a Terry Cummings. Actually pretty extensive complaint, although some of what's covered for a variety of reasons, we would argue it's not substantiated outside of the statute of limitations, so we just didn't have evidence to support it. Ms. Thomas was served with a complaint on or about June 14, 2018, and she was also sent a subpoena. Ms. Thomas did not provide a written response to the complaint or to the subpoena. That 2019 case, there's a overlapping period of maybe just 1 month of June, and so I won't cover anything related to June 2018 going forward in this presentation. I'm only asking up to May 2018 be considered. And so, just this is what we have that relate in that covered period. There are 5 CCDRs, 1 PFDS, 3 CCDRs that are not filed at all, and 1 PFDS. And then to help it be more understandable, I put it here in a chart. And also noted at the bottom that Ms. Thomas filed a CCDR for December 31st, but was not required to. And it was actually filed late and amended, but here's just a pictorial of what Ms. Thomas filed, what she did not file, what the dates are, what the grace period dates were, and why these things are late. I also bring to the Commission's attention that in the non-election year 2017, she actually filed a PFDS, but she filed it in the middle of 2017, and the law does not allow for it to be filed until the following calendar year, and so that is why we deem this not filed at all. And then these are CCDRs.
Can you go back to the last slide? Why in the first row there's 2 dates are the same, one's circled in red and one's not circled in black? What's the difference?
Well, because the one circle at the top in the red is when she filed her original, and then the second is the amended. And so,
Same day.
same day. And the amended just wasn't being late since
Got it.
it's an amendment. And I misspoke on this one when I said that, I just referred to this as PFDS, but this is just a continuation of the CDR. And so on here is where there's the PFDS for 2017, where Ms. Thomas actually filed in the middle of 2017 for 2017, when it actually could not be filed under the Act until after January 1st of 2018, which is why we deemed that not filed. And so for those reasons, we ask that the Commission find that there's a reasonable basis to believe that Ms. Thomas did violate the Act by not filing and late filing CCDRs, PFDSs, and also impermissible use of campaign contributions.
Okay. And was Ms. Thomas, did she receive notice of this service? She did?
Yes, she did.
And did she respond?
We received no response from Ms. Thomas.
Okay. Has anyone spoken to her? Like communicated telephonically? No.
I can't speak to what occurred when I arrived,
Yeah.
but I have not spoken.
No.
We haven't heard from her on either of her active cases, which it spans about two and a half years. So,
How was she served?
certified mail.
Okay. All right, well, I'll just note for the record again, aggravated circumstances. And hopefully whenever the fee consideration comes back down, that will be brought before the commissioners. Anyone want to make a motion?
I will move that the Commission finds reasonable grounds to believe that the Campaign Finance Act was violated in 2018, 5-6, in the matter of Erica Thomas. Second.
Okay, well, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 3-0. Next, we've got a matter of Osborne Nevitt Sr.
Yes, and this will be 2 cases at once. And while we're getting this set up, I will say that Mr. Nesbitt, to our knowledge, is represented by counsel. Counsel has been served and has not responded at least to this hearing notice. So Mr. Nesbitt is actually the chairman of the Rockdale County Commission, and Mr. Nesbitt is alleged to have violated the Campaign Finance Act by accepting contributions prior to filing his declaration of acceptance of campaign contributions. And then here is the law. And if you want me to explain this, I will, but I know that everyone is familiar and I'm just trying to move through. And so, for procedural history, Ms. Bird actually filed 2 complaints against Mr. Nesbitt, and that's why we have 2 case numbers here. Her second complaint incorporated the first complaint and also included some ethical allegations that related to county operations, which were outside of the scope of the jurisdiction of this commission. Mr. Nesbitt was served with legal process, and we actually received a letter from counsel for the Rockdale County Board of Ethics, who in this letter stated that the allegations that they received as violations of ethics were not substantiated, but they wanted to alert the commission that they thought there might be a violation of the Campaign Finance Act based on photographs that were included in the complaint that they received, and those photographs are also included in the complaint that's in the binder that you have. And so here's a procedural history. Ms. Bird filed a continuation of the procedural history. So before the first complaint was resolved, Ms. Bird filed a request to expedite this complaint. This actually appeared on one of the commission's agendas, and counsel, as I understand it, was present, but moved for continuance, which the commission granted, would be further evidence of counsel being aware of this matter, aside from the recently served notice of hearing with my counsel, which was served by certified mail.
When was that served?
On October 30th.
Okay.
And we received no written response today for either complaint. And so Mr. Nesbitt actually started as a commissioner for Post 1 and then ran for county chairman, and Ms. Bird's complaints that are within the statute of limitations arise out of the campaign for chairman, although her complaint, I believe, go back to 2011. And so the indicators that we have that were included in the complaint that show that there were expenditures before the DOI was filed include, there's photographs. If you look at the exhibits that are attached to the complaint, it's Exhibit 12, Exhibit 16, Exhibit 17, and I believe Exhibit 19. And those exhibits include photographs of Mr. Nesbitt, who is said to be in this one complaint, and now formally announcing his candidacy, and there are supporters or people in the photographs holding campaign signs. The supporters are said to be wearing campaign shirts. There are 2 people that may be wearing shirts, but you can't see what the detail is on the left side of the shirt, and so we would only be relying on Ms. Bird's one complaint to note that those were 2 shirts, but there are signs, campaign signs that are visible in the photographs that we have. And then there are also photographs of fan handles or what look like nail files, and that's the photograph that counsel for the Rockdale County Commission wanted to alert the commission to, because they thought that that might be evidence of violation of the act.
And when did he file his declaration of intent?
On February 5th, 2016, and the photographs are from 2015.
And how do we know that?
How do you know which
That
one?
the photographs are from 2015?
So the photographs, many of the photographs are from social media posts, and they have date stamps of, let's say 2015,
Okay.
December 2015.
So in the photos, though, how do you know that he purchased whatever the clothing items are with the campaign account?
Well, we don't know.
So we're not relying on that.
No, we are relying on the fact that there are signs and photographs that support the campaign, and whether he purchased them or they were donated, they would still be contributions, and he would have had to account for that in some way, and it still would have been prior to the declaration of, the declaration of intent.
Well, he doesn't, if there's a PAC out there that's supporting him, he doesn't have to disclose that. He wouldn't know. I mean, Bob Watts, Super PAC, wants to support whoever I want. They don't have to disclose it.
Well, the staff's position isn't that there's a 100% certainty that he made those purchases or even that they were in-kind donations. The position of the staff is that there's a reasonable basis to believe that there were contributions or expenditures prior to the Declaration of Independence, and we believe that those photographs are enough to get us past that standard.
I'm not sure I'm comfortable with that, because have we subpoenaed any bank records?
Yes, the subpoena was served on August 18, 2017.
But we didn't get anything?
No.
Yeah, I guess I'm having a hard time with just sort of, I get it, that's a logical leap, but there's really nothing to connect the two. And, I don't know, I would have a hard time just saying that automatically something that should have been reported without a little bit more. Too many think different than that.
And not my vote, I know that, but my only suggestion would be, if we do vote to go forward based on that logical leap, then we can enforce that subpoena at OSA and get clarification one way or the other.
So it's an unenforceable subpoena as it stands?
We would have to file a motion to compel in Superior Court, which I think Mr. Fuller will tell you is an arduous process, versus moving straight to OSA and then having an admin law judge with contempt powers do it much quicker.
Yeah, I guess where I'm coming down on it is probable cause with just a picture. Do we have the pictures?
They're in the binder behind the complaint, or they're part of the complaint.
Where is this held?
Yeah. One of my thoughts is that in one of the pictures I saw, he's actually, I'm assuming it's him, he's actually standing there.
Right.
And people are holding up signs. So that wouldn't be, to your point, an independent expenditure if he's participating with the signs around him.
Are the social media posts his own?
Some of them are.
There are various sources of social media posts, but they're all included as exhibits.
He's just showing all these things. I see your part, but this is his office. That's what it says. Supposedly.
All right, keep going.
Well, really, the photographs that are included, specifically photographs that include social media posts about the campaign and the photographs that show campaign paraphernalia are the evidence that we're looking at, because there are other exhibits that are not really relevant to what the commission's charges. I think are just intended for some other purpose.
Here's this one I was talking about.
Is that it?
That is
Okay.
it. Based on that, staff asked that the commission find there's a reasonable basis to believe that the act was violated.
Yeah, I mean, I think, I think that it's not a beyond a reasonable doubt standard. I think another explanation could be that a super PAC purchased it. I think that is highly, highly unlikely in a small, what kind of race is this?
This is the county chairman in Rockdale.
Yeah, I think, I don't think a super PAC is chiming in as the county chairman.
Is it, Exhibit 11 actually shows a business card with his face on it, his email address, that somebody had to pay for, so.
Yeah, I mean, definitely there's an explanation, it could be. But I think because it's not a beyond a reasonable doubt standard, it's a reasonable ground standard that, I think the reasonable ground exists. But I'll make that motion, we can vote on it. I'll move that reasonable grounds exist, that in the matter of Osborne Nesbitt Senior, the act is violated.
I'll second that.
All right, we got a motion, we got a second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right,
I do
motion.
have a comment. So I'm basing my eye primarily on this Exhibit 11 that Commissioner Thompson just showed me, which is a business card that says Oz for Chairman, something that obviously benefits him with his face on it. This hashtag Team Oz, which is part of the signs and the other things we provide them. But I understand that a super PAC is probably not done with this race, but I would caution the commission staff that going forward, I think we need a little bit more. And whether it's an arduous process or not, let's do it. That's
I think that's fair. I think that is fair. All right, let's keep rolling. So in the matter of Thomas Cheek.
And so Mr. Cheek was a candidate for, well, he sought nomination for the Republican primary for the Cobb County Commission. I believe it was District 3. He was an unsuccessful candidate. And the allegations are simply that Mr. Cheek did not file all of the required reports. Mr. Cheek felt the allegation is that Mr. Cheek violated the act by failing to file the June 30th, September 30th, October 25th, and December 31st reports in 2018. His election was actually in May of 2018, and he filed the 2 reports prior to that, but did not file any subsequent reports. Mr. Cheek also did not terminate his campaign, so there's an ongoing requirement. Mr. Cheek case arises out of a third-party complaint from Ms. Miller. Mr. Cheek was served a legal process on July 28, 2018. Additional allegations were mailed to Mr. Cheek on November 19th. Those additional allegations included the months beyond June, because Ms. Miller's complaint was only for the June report that was not filed. Mr. Cheek has not filed a response with the commission. So those are relevant dates. And so this is just a graph of the reports Mr. Cheek did file and the ones that he did not file. And based on that, the staff is asking that the commission find that there's a reasonable ground to believe that the act is violated.
I'll make a motion that there is reasonable grounds to find that the Campaign Finance Act was violated in matter 2018-100 in the matter of Thomas Cheek.
Second. All right, my only question is service. Was he served?
He was served.
Okay.
Okay.
And did you speak with him?
No, I have not spoken to Mr. Cheek.
Okay, has anyone spoken with him? No. So no indication why he didn't come today? All right. I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries. So is that all the preliminary hearings?
Yes.
Yes.
Okay. I would propose we move that we adopt these consent orders en masse, unless there's a reason not to. All right, who's going to present those, or present the overall?
I'll present the first 4, Mr. Cusack can present the last 2, and then y'all can vote
Yeah.
as a block.
That's what we should do. And just,
Yes, so I will present 5. Mr. Cusack will present 2, and are there any others? Mr. Lane, that's 3. Well, what I'll do is I'll start with the first 4. You can have a mic. I'll start with the first 4. And these are all members of the state legislature that were part of the audit of the State House and Senate. We'll start with Representative Saines. Representative Saines is a Republican from Woodbine. House District 180, first elected on November 6th of 2018, so he is in his freshman year. Mr. Saines had some issues with the June 30, 2019 CCDR. He hit the zeroed out button. Mr. Saines indicated he was actually out of the country, had some issues with it. Ultimately, we filed the complaint. He immediately complied with subpoenas. The extent of the issues weren't that he didn't disclose 3 contributions in the amount of $2,000. Well, like I said, he did comply with subpoenas, and he has agreed to pay a fine in the amount of $875, which I think mitigating that he was remorseful and he was cooperative and it was his first year in office, I think is reasonable.
Okay, keep rolling.
Next, we have Representative Nikki Stevens. Representative Stevens is elected state representative of the Democratic Party from Savannah. He's been in House District 176 for a little over a decade. Candidly, Mr. Stevens had a little under $10,000 in contributions that he didn't disclose over a period of roughly a year and a half. He also had about $7,000 expenditures. I have actually agreed to enter into a compliance order with Representative Stevens. Representative Stevens has been in and out of the hospital for the last 2 years, suffered a leg amputation. I don't know that he'll be physically capable to come back to session just yet. He actually had to leave session during the 2019 legislative session midway for hospitalization. He has agreed to a compliance order where as soon as he is physically fit and able to get back to Atlanta, he will sit down and undergo training with the commission to ensure this doesn't happen again. But we've corroborated this has been an ongoing long-term medical issue. Members of the State House of both parties have reached out and vouched that he's typically been good, but has been in very bad health, so I thought that was reasonable given the circumstances.
Why on the findings of fact are we saying that he didn't file December of 2019 report, since there is no 2019 yet? Just a question.
No, it's a typo. Yeah, that's a typo. That would have been 18. So with the block vote, maybe someone can motion an addendum to that December 2019 and maybe 2018. But other than that, I would propose the compliance order given his health issues. Next, we have Representative Gardner. This is actually a little more serious case. Representative Gardner is a state representative of the Democratic Party from Atlanta, first elected to House District 57 in 2001. On 4 occasions, Ms. Gardner failed to file a CCDR of any kind in September 30th of 2018, October 25th of last year, January 31st, and January 30th. In total, she failed to disclose $10,346 from 31 donors during that time period. She additionally failed to disclose over $20,000 in expenditures, and she failed to disclose that she accepted 3 contributions in the amount of $1,200 during the 2018 legislative session. Ms. Gardner has agreed to enter into a civil penalty in the amount of $8,500. Ms. Gardner has also indicated that she will not be seeking re-election and will be retiring from public office. Next, we have Representative James Burchett, a Republican state representative from Waycross, first elected on March 12th of this year in a special election that actually went to a special election runoff. He was late on one of those special election dates, and then he failed to file a runoff date. As a result, he failed to disclose $18,000 from 28 donors over the time period in February and March. And he failed to disclose $12,000 in expenditures. Mr. Burchett, like all of the representatives, I want to be clear that we're dealing with now, were extremely cooperative. Initially, we were looking at a slightly higher penalty, but because it was a special election and one of those funky special election 6-day runoff dates in his first run for office, we agreed to pare that down to $2,500. Finally, the last one I'll present, Senator Chad Brahman, Democrat from Lawrenceville, first elected to the state Senate on November 8th of last year, so he is also a freshman. He failed to file or properly file the September 30, 2018 and June 30, 2019 reports. He failed between those two to file $331 in contributions from 11 donors and a little under $2,000 in expenditures. There was some question as to whether he accepted contributions during session, but digging into it, it looked like it was user error on his part, so we agreed to pare that down to a $1,000 fine.
And I have Gary Thomas Brown. Mr. Brown was the chairperson of the Friends of SPLOST committee, ballot committee in Butts County. This violation was for actually the whole committee. It was for a ballot question on whether a 1 cent SPLOST would pass in Butts County. The sole violation was that they filed late. They were under the impression that they filed on November 7th, 2017, when the election actually happened, or when the SPLOST question was on the ballot. They filed that day. They should have filed 15 days beforehand. They admitted that they violated it. They raised about, I think, they expended $448 and received about $1,300 in in-kind contributions. So they agreed to pay $250, $125 as a civil penalty, and $125 in a late fee, and they've already paid that. I next had Mr. Henry Wayne Howard. Mr. Howard is the House District 124 state rep since 2007 in Augusta. He is a current member of the General Assembly. He was part of the legislative audit. He had 3 failure to files. It was March 31st, 2018, December 31st, 2018, and January 31st, 2019. And then he had 6 late filings. That was December 31st, 2016, January 31st, 2017, June 30th, 2017, January 31st, 2018, October 25th, 2018, June 30th of 2018. Those were actually filed as zeroed out reports. He complied with our subpoena, gave over his bank account records. He took in $1,000 during that time in contributions, reported those contributions. However, he did file those zeroed out reports and made expenditures. Now, those expenditures were mainly on his own dime, and it was for things related to the campaign. So he had about $21,886 of expenditures that were not reported. However, it was most of his own money and all related to his housing, things related to that. He also has undergone serious hardship as well. He provided documentation to us of him being in and out of the hospital. He's a double amputee and had complications where he was in and out of the hospital. And some of these, he was not in the hospital, which is why we've agreed on a $5,000 civil penalty in this case, or a $5,000 penalty. Some of these were zeroed out reports, and he should have basically trying to deceive and going back and filing and never did. So they were zeroed out reports where there should have been something reported. But he also had some mitigating evidence in terms of his health at the time. So that is why a $5,000 civil penalty is agreed to in this case.
And this is going to be paid over 3 years?
Yes. There's some financial hardships as well. So that's the agreement I've come to with him. All right, is that it?
Almost. Commissioners, you have a consent order in case number 2019-0033 PC in the matter of Brenda Lopez Ramiro. Ms. Ramiro serves as, she is currently the District 99 representative for Georgia House of Representatives, most recently elected in 2018. She failed to timely file 3 reports, those being her June 30th, 2019 CCDR, January 31st, 2019 CCDR, and her December 31st, 2018 CCDR. She has agreed to the payment of a $1,200 civil penalty and $625 in late fees. Additionally, you have the case of Mr. Winford J. Dukes. That's case number 2019-0034 PC. Mr. Dukes currently serves as the District 154 representative of the Georgia House of Representatives, most recently being elected in 2018. Mr. Dukes failed to file his June 30th, 2019, January 31st, 2019, December 31st, 2018, October 25th, 2018 campaign contribution disclosure reports. He failed to timely file his September 30th, 2018 campaign contribution disclosure report, and he failed to disclose approximately $2,600 in campaign contributions and $1,880 in campaign expenditures between September 1st, 2018 and September 30th, 2019. In consideration of these violations, he's agreed to pay a $2,300 civil penalty, along with late fees totaling $750 for a total penalty of $3,050. And then as to Dexter Lenora Sharper, case number 2019-0039 PC, Mr. Sharper serves as the District 177 representative of the Georgia House of Representatives. Mr. Sharper failed to disclose approximately $2,600 in campaign contributions, $2,717 in campaign expenditures between March 31st, 2018 and June 30th, 2019. And that would cover a number of campaign contribution disclosure reports. Representative Sharper has agreed to a civil payment, or civil penalty in the amount of $1,500. And he has amended his disclosures to report his actual disclosures.
So I know we're about to vote on these a lot, but I think I just want to make a couple of points on, particularly with consent orders, maybe sometimes with preliminary hearings with individuals not here. The first one is with respect to describing hardships. We trust our staff. Let's keep it at a high level. If it's a medical hardship, it's a medical hardship. If it's a financial hardship, it's a financial hardship. Senator Lucas is different. He wanted to come in here and tell us himself. But for those that aren't here, we can keep it at a high level. And the last thing I'd mention is that it seems like a number of these folks with the consent orders were freshmen, maybe not most of them, but some of them at least. So, something to consider in the future is some sort of training program for freshmen or those who are in runoffs that may have a lot going on and not necessarily paying attention to the final deadlines.
They are required to go to the biannual, that once they, after the elections, the legislators are there, and then our staff is always there doing presentations about legislature reports.
And to your point, Commissioner Watts,
I've actually had positive conversation with both majority and minority leadership from the House and Senate about doing training sessions, not just for the freshmen, but for all of them.
Sure.
So that's probably something we'll be looking at doing moving forward, particularly with a new software system expected to roll out by 2020. They're all going to need to relearn, what software they're reporting into as well.
Okay. All right. My only comment is I want to applaud the staff, Secretary Amati, Mr. Lane, Mr. Cusack, Ms. Browder. I thought you guys each did an excellent job. The PowerPoints are greatly appreciated. They make it a lot easier for the commissioners to understand all the facts in a short period of time, but I thought it was organized, polished, and professional, so I want to applaud each of you guys for that. So with that, I'll make the motion subject to the 2018 change in the matter of Mickey Stevens to adopt and block each of the consent orders that were just presented. And I don't know if we have the numbers. Let's see, we've got in the matter, or I'll call out the numbers, 2019-0032 PC, 2019-36 PC, 2019-0037 PC, 2019-0044 PC, 2018-0034, 2019-0053 PC, and then we had Sharper, which is 2019-0039 PC. Tate was continued. What other one did we move down to consent? Dukes. Dukes is 2019-0034 PC, and then Rodman is 2019-0040 PC.
And then Romero.
And then 2019-0033 PC.
And Mr. Dexter Sharper.
Yeah, I got that one. Okay, so moved. I have a second to adopt those consent orders. Second. All right, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, so we've just about got the agenda knocked out. Next, we'll have the report of the Attorney General.
Thank you, Mr. Chair. I'll be brief. I just want to come back to Commissioner Watt's point about the arduous work. I would like to think that all of the work that I have to do on a day-to-day basis on behalf of this commission is quite arduous, so. You guys keep me gainfully employed.
And we thank you for it.
The only update I have is to just give a status on the Attorney General opinion. I've been told to share that the opinion is undergoing final review. I will say that, so two things. One, to credit Mr. Amati, Mr. Amati has reached out, and Mr. Evans, or Chairman Evans, you asked last time if the commission needed to reach out to facilitate the movement of the opinion. Mr. Amati has done that. I will say that the questions being asked, they have presented some fairly novel issues that the office is, for lack of better terms, really trying to digest the issue, the highest quality opinion it can to give guidance to the commission on this issue. So to the extent that I've continued to press those to get the opinion finally approved, I've done that, and I'll continue to do that. As soon as it is signed off and approved, I will let Mr. Amati know, and then he can inform the board. But it's under final review right now.
Okay, well, thank you, Mr. Fuller. Keep us informed. All right, scheduling of dates for 2020 quarterly commission meetings. Given we have two commissioners out, I would propose that you guys circulate a couple dates and we can try to work together. Hopefully it's not too burdensome, but I don't know how productive it'll be 3 out of the 5 unilaterally picking dates, so just send some of those out. We'll work together on that. And public comment. Do we have anyone here that's going to provide public comment? Okay. Well, with that, I will adjourn the meeting, and I'll make the motion to adjourn the meeting. I appreciate the commissioners and their preparation today. I know it takes some time to review all the materials and get through everything. I thank the staff, and I thank each of you guys for coming out. And with that, I'll move to adjourn the meeting if I can get a second. All right, second. I'll call the question. All in favor, say aye. Aye.